Yeah, please.
Yes.
My lord, item number 55, my lord. Item number 55, my lord. Petitioner bank account was frozen, my lord. Now in the meantime, my lord, all restriction has been removed, my lord. So I may be allowed to withdraw this petition, my lord.
What do you want?
Withdrawal, my lord.
The mic is working. AHMR Chaudhary, the learned counsel, appearing on behalf of the 11. That he has instructions to, he has been instructed by the petitioner to withdraw the writ petition. Accordingly, the writ petitions used on withdrawal, same orders, if any, stands vacated.
May I please, Lordship? Lordship, I beg to mention item number 22, daily list of admission column. Lordship, I'm praying for a short accommodation since my senior is out of station and he could not return back due to flood situation in
The
Gauhati.
whole matter, Mr. Counsel,
Pardon me, sir?
the whole matter, 2020 matter. 6 years have already passed by.
Yep.
When the matter reaches,
Lordship, my senior is out of station and
what, and help you.
Second petrol.
Yep.
Second petrol.
You prepare the matter by yourself.
Lordship, my senior is out of station and he could not return back due to flood
What?
situation. He could not return back due to flood situation.
We'll see when the matter reaches.
What's up?
Okay. No, 50. Aman.
Wait,
No,
wait, wait.
Rohan.
So this matter pertains to transfer of prisoners.
What has happened here?
Lordship, the state of Assam has written to the state of Manipur. And I
You
believe-
want your directing him to pass necessary effectuating prompt transfer of the instant petitioner from the district jail Morigaon to central jail so and so.
Yes, Lordship. Lordship, now under the Transfer of Prisoners Act, there is a consent order that needs to be passed by the state of Assam after having obtained the consent of the state of Manipur. I think Mr. Singh appears for state of Manipur. He has.
Yes, madam. Has the order been passed?
May I hand over the Prisoners Act? Lordship?
But so far the matter of Manipur is concerned, I have been intimated, we have no objection here. There is a obligation.
It's okay. You have no objection, but it is the requirement of the state government of Assam to pass. Have you passed this order?
Malat.
Or have you taken into consideration the state aspect?
Look, we have instruction on Malat 6th of June.
What is that?
There, Malat. That's why I'm being promoted. Transfer of the two. Yes, Malat. Yes, Malat. We have written to them, Malat. If state of Manipur is accepting them, Malat, we have no objection, Malat. This is our instruction, Lordship, may be pleased to produce.
But then why do you need an order from the court?
Because we're waiting for
See
their.
the prisoners transfer order act, which
Yes,
is
sir.
it.
May I hand over the.
We are waiting for their Malat acceptance, Malat.
Lordship, I'll just hand over a copy.
No, I don't have that copy. If you can that copy, I don't. Go through it.
Yes, where is the provision?
Lordship, Section 3. Removal of prisoners from one state to another.
Yes.
Lordship may have, if I may read, where any person is confined in a prison in a state, Lordship will have B, under or in lieu of a sentence of imprisonment or transportation. Or C and D, Lordship, not relevant. The
So
government of,
therefore,
yes,
the government of Assam may, with the consent of the government of Manipur,
yes,
provide for removal of the prisoner from
Prison
Morigaon prison
yes.
Yes.
to the prison of the other state.
Please, my
Then why you are not passing that order?
My lord, now we have, see, my lord, they,
But
today-
now,
yeah, that day only I could
this
come to
letter
know,
has
my lord,
been-
regarding acceptance, my lord. We are
this
waiting.
letter has been written to the Director General by so and so.
Yes, in
Okay,
the month of June.
take
my-
note of this
My lord.
and give an update to this.
Lordship, lordship.
The present application has been filed by
two,
Yeah.
two convicts.
the two petitioners who are presently lodged in the district jail at Morigaon.
Morigaon.
Being transferred to the central jail at at Imphal, Manipur. Imphal, na?
Impal.
To the Manipur
Central jail.
Central Jail,
Jiwa.
Diwa. Full stop. The case of the petitioner is based upon Section 3 of the Transfer of Prisoners Act 1950, which provides which empowers the government of the state wherein the prisoner is lodged with the consent of the government of the other state where the prisoner is to be transferred for removal of the prisoner from the prison of that prison to any prison of the other state. In the instant case, it is seen that pursuant to the request so made by the petitioners, the Deputy Secretary to the Government of Assam Home and Political Department had written a communication to the Commissioner bracket Home, Manipur Secretariat, Imphal, Manipur, seeking consent of the Government of Manipur for transfer of the petitioners from the district jail Morigaon to Sagia, Sagiwa, jail, Manipur. Mr. N. A. Singh, the learned counsel who appears on behalf of the state of Manipur, have also placed the communication issued by the Superintendent of Prison, Manipur Central Jail, the Director General of Police Prisons, Manipur, wherein it is categorically mentioned that the two petitioners can be accommodated in the Manipur Central Jail, Sajiwa. The communications which have been placed before this court, dated 4/6/2026, issued by the state of Assam to the state of Manipur, as well as the communication issued by the Superintendent of Prison, Manipur Central Jail, to the Director General of Police Prisons, Manipur, are kept on record and marked with the letter Y, X and Y respectively. Taking into account the said consent, comma, and the submission of Mr. N.A. Singh, the learned counsels appearing on behalf of the state of Manipur, that the state of Manipur has no objection in the transfer of the petitioners to the central jail, Sajiwa, in the state of Manipur. It is the requirement of Section 3 of the Transfer of Prisoners Act 1950 for the state of Assam to do the needful. Accordingly, list this matter on 17th of August 2026. An update be provided by Ms. Udas, the learned additional senior government advocate, as to what steps have been taken by the state of Assam in pursuance to the no objection issued by the state of Manipur.
My lord, with all respect, my lord, this has been written to,
Understood.
but no, not to the state of Assam. my lord.
Understood. That is why I have passed this order.
My lord,
Otherwise, why should I pass such a long order?
I'm yet to, madam, state of Assam is yet to receive, my lord.
This you have received. He has submitted that, na? He has already submitted that document to you. So
Not-
therefore, and therefore, why I didn't only mention about only the superintendent. I therefore mentioned about his submission.
Lordship, I could
That
understand.
is the reason why. Because the state of Manipur has no objection. That is what he has
My
stated.
lord, his submission.
Lordship, just one more aspect. There is a state law, the Assam Prisons Act 2013, that there is a provision in for transfer as well, but it refers back to the Transfer of Prisoners Act 1950.
Okay.
It's there.
My lord.
You send a copy of this order to the person concerned.
May I please, Lordship, in item number 1, Lordship, I need some accommodation regarding whether the matter has become infructuous because we have not been able to contact the petitioner at this stage, Lordship. Lordship, one last chance may be granted to us.
এইকেইটা 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 আমাৰ ন এইকেইটা এইকেইটা আমাৰ কৰি পেলাই নাই চাগে এটা নিশ্চয় দে ইফালে থৈ দিম তাতে থৈ দিম।
What is the case about?
Lordship, the matter is regarding a land dispute, Lordship. I was in possession of a land and respondent number 89 illegally, they were trying to encroach into my land. Because of which we had filed an FIR also because they were trying to dispossess us from the land. And then we had filed a title suit also regarding the claim and demarcation of the land. Now, while we were contesting, Lordship, now we have lost touch with the petitioner, so we do not know.
No, you have filed the title suit.
Yes, Lordship.
What is the number?
Title suit number, Lordship. There is
What is
a,
the-
title suit number 73 of 2016, Lordship.
Pending
Before the Munsif court, Lordship.
before the municipal where?
Guwahati, Lordship.
Number
Lordship. 73 of 2016, Lordship.
huh?
73 of 2016.
Pending before the municipal.
Court Kamrup, Lordship.
See, when you are saying Gauhati, I'll know that.
Yes, Lordship.
How many municipal we are having in Gauhati?
Lordship. The
Four.
Four. Lordship, I am not. Yes.
Now 5. Then
Yes, Lordship, that Lordship, I have.
this type of
Lordship, I do not have the updated instruction, Lordship.
Sale papu. No. Better take to e-court to my lip. You have to be prepared when you are coming before
yeah,
this court, Mr.
Lordship,
Solia.
Lordship,
This is not what we expect from a council.
Lordship, here we have not been
This
able to.
sad state of affairs.
Lordship, I apologize, Lordship.
You
Today,
should.
Lordship.
You should give a written apology,
No, Lordship, here.
not this type of apology.
Lordship,
Apology, a verbal apology, it does not. It doesn't. It's not befitting a council out here to
Lordship,
be appearing before the court saying the munsif.
Lordship, I apologize.
So 73 of 2016 Saksu, what is the status? I think this must have been disposed of now.
Yeah, Lordship, I am. Yes.
E-court of Sarepa. Understood. That I know.
Lordship may have it at 2. I'll try to contact, or I just need 1 day's accommodation, Lordship. Today the matter has come suddenly, because of which we were unable to. If tomorrow, Lordship, I'll be more prepared, Lordship, and I will try to get in at least an
Okay, 10,000 cost upon you.
no, Lordship.
Yes, yes.
No, no,
Don't you think that the court has other matters?
yes, Lordship.
When a matter is being fixed in the court, you must be knowing it.
No, Lordship, the earlier engaged counsels, they could not appear, Lordship. So,
Earlier engaged counsel,
yes,
he's in your same chamber.
yes, Lordship. They have not been able.
Now he cannot appear because he has now been appointed as the standing counsel.
Yes, Lordship.
That's it.
Yes, Lordship.
Well,
Uh,
this type of things doesn't happen like this. মই ওলাই দিছো সাধাৰণ বস্তু এটা ওলাব নোৱাৰে আপুনি It doesn't take 2 minutes to find out. The matter is taking long because of you.
Lordship, I apologize.
The matters will be then dealt with later on. Don't worry. মানে এইটো ভাল নাই
Seven.
ইণ্টাৰনেটৰ মানুহকেইটাক মাতক What has happened? Not done. Do people want to do advance out here?
No,
This is
Lordship.
the status of affair.
j-
All the people from internet. Why the internet is not working? High Court.
2016. Yes.
Yes. What is the status? মোৰ ইয়াত খোলকচোন Put this in my computer. তুমি কি খুলিছে? I don't require all these things. এইটো ই কোর্সটো চাওক ওপৰত চাওক Yes. ক'ত যাওক ডিষ্ট্ৰিক্ট যাওক ডিষ্ট্ৰিক্ট কামৰূপ মেট্ৰ' কৰক এইটো ওপৰত যাওক ক'ত 17 MSCT নাহে নহয় আপুনি ক'ত খুলি আছিল এইটো ইয়াত স্ক্ৰীন কৰিব নোৱাৰে নি স্ক্ৰীন হয় নহয় I'm asking you whether it is get screened out here or not. Read that.
In our affidavit, my lord, it is mentioned.
Don't require this matter is to be dismissed.
No, that court number, my lord, I have just located it. It is Munsif Court number 1, Kamrup Metro. That is being mentioned in our affidavit.
Why it is not coming here? It is coming. Now disposed of. It to order tomorrow. Now it to shock. Captain Abeyance. Abeyance. Back correction. Back correction. What is the status? Abeyance, necessary orders. Service report. Pending court. Junior division number 3. তলতে হওক একদম তলতে হওক Art Mr. A. Soliha, the learned counsel appearing on behalf of the petitioner. Nugusa boyuka. Don't remove it from. Mr. M. Bormon appears on behalf of the respondent numbers.
One,
127.
inside.
Huh?
One, two,
Revenue.
1 to
four, three,
7.
3, 4, up to 7.
That is what I am saying also. 1 to 7. None appears for the respond number 8 and 9. Next. The present writ petition has been filed by the petitioner. Being aggrieved by the actions on the part of the respondent numbers 8 and 9,
eight to seven.
in taking steps for dispossessing the petitioner from the plot of land at measuring 1 bigha covered by dark number 702 bracket old oblique 3440 new included in KP Patta number 29 old oblique 605 new of revenue village Borsozai under Moza Beltola in the district of Kamrup Metro Assam. This court have duly perused the material, the writ petition, and a perusal of the writ petition reveals that it is a purely a civil dispute between the petitioner and the respondent numbers 8 and 9. It is also saying that the petitioner, in order to invoke the jurisdiction under Article 2 to 6 of the Constitution, have arrayed the respondent numbers 1 to 7 of the writ petition. It may not be out of place to mention that there is already a suit filed by the petitioner. Name of the suit to sound? Upor le ho. Upor le ho. Upor le ho. Aur upor jao. Upor jao. Upor jao. Show the name of the year. Tolot hok. There is already a suit filed by the petitioner. Pending before the Court of the Civil Judge, Junior Division number 3, Kamrup Metro at Gauhati. Been registered and numbered as title suit number 73/2016. Taking into account that there is already a suit pending and the dispute in question is purely a civil dispute, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Before parting with the record, this court makes it clear that the dismissal of the petition, the present writ petition, shall not affect the inter se rights of the petitioner as well as the respondent number 8 and 9 in title suit number 73/2016. Please. Yes, what is this?
My lord, in this petition, we have challenged the jurisdiction of an FIR under 226, my lord.
Why?
Because it is an identical FIR. Similar FIR was filed in Gauhati as well, where a closure report was filed. Thereafter, my lords, with same facts of FIR was filed in Visakhapatnam, even though petitioner never visited Visakhapatnam. during that period. So, my lord, we challenged the jurisdiction, my lord, and for a long time, my lord, the notice was not complete on the private respondents. So, my lord, we had filed an IA 1820 of 2024, my lord, seeking leave of this court for newspaper publication in Visakhapatnam, my lord, where the FIR was filed. Thereafter, my lord, after the newspaper publication, we filed an affidavit where we have annexed, my lord, two publications in Hindu and Times of India at Visakhapatnam, my lord. So my today, my lord, service may be, my lord, deemed complete, my lord, based on these newspaper publication.
In view of the of order passed by the Law Sabha Court dated 26/6/2026. 4 deemed to be complete. Accordingly, list this matter for admission on 10th of August 2026.
Obliged.
Yes, my lord, respondent has to file affidavit. That was the matter of barter system, my lord. It was closure of barter system, my lord. Reserve Bank also allowed, my lord.
You were required to file additional affidavit.
We also, my lord, but we also, because of the present.
No, my
situation-
question is, are you going to file the additional affidavit on?
Yes, my lord.
You know, you can't.
Because
No,
of
no.
money.
3/3/2026, the petitioner sought for 3 weeks' time for filing an additional affidavit to bring on record certain subsequent developments. However, no such affidavit have been filed. Consequently, the petitioner is debarred from filing any additional affidavit in the instant proceedings. List this matter for admission on 14th of August 2026.
Last occasion, your lordship, the respondents have prayed that they will file an affidavit, the BTC. This case,
Yes, BTC. What is the matter about?
this case, your lordship, there are illegal mining going on in Mora Pagladia River, and we have been praying that
An action on the part of the
mining should stop.
particularly the respondent six regional forest of to do thus to extract the sand and stone. Mark of 2023 to back. Cutting the difficulties of the villagers of the whole village. Who are you?
For the petitioners and residents of the villages, your lordship, we are affected because of this case, your lordship, because of the illegal sand mining.
Why? It has been given by whom?
This has been given by the authorities, your lordship, the regional forest officer, page 53, your lordship.
Page?
53.
To work for that fix. I mean, if you are here by land. The divisional forest officer, Baksa Forest.
Yes, your lordship.
Baksa is under whom?
BTC, your lordship.
BTC, none appears for the BTC. What about the service upon this person concerned?
Respondent number 8, the service is complete. He has not appeared, your lordship. Respondent number 8 is the person who has been issued the final work order, your lordship.
What is your difficulties?
Your lordship, we have filed representations. Your lordship may kindly peruse our representation.
Okay. Leho. None has appeared on behalf of the respondent BTC. Yes, for on behalf of the respondent number 8. Also, neither any affidavit has been filed on their behalf. Consequently, list this matter for admission on 21st of August 2026. First,
Very grateful, your lordship.
yes, Anita.
Item number 19, 19.
What is this IA for? Who is appearing in this matter? Evan,
Lords, I am for the petitioner in this matter. Lords, I may be given some time in this matter. My instructions are not complete. The IA copy is not available with me right now.
you are appearing for the petition and your copy is not available with you?
Lords, I am sorry, Lords. I missed this matter. I just got to know about it that an IA is listed. I may be given some time to assist Lordships.
The counsel appearing on behalf of the applicant is not ready. Accordingly, the matter stands adjourned to be listed after 6 weeks.
Please, Lordships.
Eight. Same. 8 is also same. Yes. What is the disobedience you are referring to?
Your lordship will kindly turn to page,
Where's
Para-
the order?
it's at page 68, 63, your lordship.
Page?
The order starts at page 52, 50, it's at operative portion is at page 62.
What is the case?
Your lordship, there was a tender process initiated by the Inland Water Transport. I bidded for the same. Now, in spite of that, they could not hand over one of the empty vessels to me.
What is the direction?
The direction is at
Shall
page
remit
60.
the petitioner the full amount of rupees 8 lakhs within
Yes, your
30
lordship.
days from the date of receipt of the certified copy of this order.
Yes, your lordship.
Direction for release or arrears shall be complied by them even them by the respondent. Okay. Who appears for the respondent? Who is the respondent number 3 and 5?
Your lordship, respondent number 3
Transport
is,
Department
yes, your lordship.
and 5 is inland. Yes, who is appearing?
Your
Who was
lordship,
the counsel?
Your lordship, the copy was served upon them 17/7/2000, 17/7/2026. The office order shows that the AD has been served upon her and it has returned back, your lordship.
Is issued upon the solo. Why you are making only one person a party
Because we have served the copy only to her, your lordship. To
and
the,
not to the respondent number 3?
because I have served it upon the director only, your lordship, and it was
What
duly
was
for,
the direction passed?
the direction was the respondent number 3 and 5 shall remit the petitioner the full amount.
The date of the certified 30 days from the date of receipt of the certified copy.
Yes, your
So
lordship.
there is a twin direction to both.
Right, your lordship.
So why have you taken steps only upon respondent number 5? Not maintainable.
Yeah.
Not maintainable. What to do? Yes, BTC. Why don't you appear in these matters?
So I'm extremely apologetic, Lordship.
No, you have to written apology, not by
I'll do it right now,
verbal.
Lordship. Very
Why
sorry,
have
Lordship.
you want to appear in that matter?
Lordship, I'm very sorry, Lordship.
First, not filing an affidavit.
Lordship,
Not
what has happened in this
expected
matter
from-
is that, Your Lordship, that case is pertaining to a case which is pending in the National Green Tribunal, Lordship. Which
Therefore, you should have come up with an
Lordship-
affidavit. Why haven't you filed your affidavit?
will file on exit positively, Lordship. I'm very,
No, we know. We don't know anything about this thing. You have not filed your affidavit, my order has been passed. I can't help you.
I'm tendering my unconditional apology, Lordship, for not being Your Lordship.
Written,
Lordship,
written apology, filing, then we can.
Lordship. Right now, I'll do that.
Your petition is not maintainable.
Your lordship, at least I have filed before one of the
For
respondents.
what? There was a direction to 2 persons. Why have you made only one?
Yes, your lordship, I have, your lordship is correct. That part has been missed, your lordship.
So
But
you
at
need
least
to
she's
withdraw
there.
and file it. When was the judgment passed?
Your Lordship, it's almost 1 year, Your Lordship, more than 1 year. The judgment was passed on 10/6/2025.
Hold of the MD Bora, we'll take it up after some time.
Yes, Your Lordship.
MD Bora mati diyo.
I'm deeply obliged, Your Lordship.
Meet, please, Your Lordship, due to inadvertent oversight, I failed to notice the listing of the matter before Alabazima Court on 16/7/26, Your Lordship. The absence was never deliberate or intentional, Your Lordship.
Yes, why haven't you taken steps?
Your Lordship, the respondent stays in the same village, Your Lordship. I may be allowed to take dusty service, Your Lordship.
Okay, argue the matter. On disposal of miscase number ER pending before the ER at the Amingaon for correction of the revenue records. That's it.
Yes, Your Lordship.
We are not disposing it. Huh? Quash the mutation order dated so-and-so to incorporate the name in mutation by the so-and-so and the mutation of the so-and-so could not be set aside. Okay, why you're not filing an appeal there against?
Your Lordship, already one second appeal is pending before this honorable court.
No. When there's a mutation order
Yes, sir.
passed by the circle officer, why you're not filing an appeal? Who has passed the mutation order? Let's see, 2017. Where is the order?
Our mutation order, Your Lordship.
That mutation order which you have challenged. Your petition is, this petition you can't file it, an application for cancellation of the mutation. No, that person officer does not have the jurisdiction. Functions officio. You have to challenge it. Either you have to file a review or you have to challenge it out there. The review jurisdiction is not there. So you have to file an appeal before the ADC.
Your Lordship, my mutation order is still pending, Your Lordship. It's not been disposed of, Your Lordship.
So where is the impugn order?
Impugnator, Your Lordship, I was not served with certified copy, Your Lordship. That's why I could not annex it, Your Lordship.
Huh?
I was not given the certified copy. That's why I could not annex it, Your Lordship.
So get hold of a certified copy and challenge it for the ADC. The mutation of what is the order dated you are challenging? 22/11/2017.
Yes,
So you are challenging in the year 2026. Very good. What more is required? Why? No, we can't entertain this type of way. Where is the order? By the main counsel.
No, Your Lordship, my senior is there, Your Lordship. D. Chaudhary, Your Lordship.
Where is he? And why haven't you taken steps upon respond number 4, 5, 6, and 7?
Your Lordship.
The hook. The present petition has been filed assailing the order dated 22/11/2017 mutation case number KAM/UTT/2017-818/753/FMUT by the Circle Officer, North Gauhati Revenue Circle, whereby the land was mutated in favor of the respond numbers 4 to 7. Pusto. A question arises as to whether the present petition would be maintainable, taking into account that the petitioner had an alternative remedy by filing an appeal against before the Deputy Commissioner in terms with Section 147 of the Assam Land and Revenue Regulation 1886. It is also seen that the petitioner, in spite of notice having been issued on 4/2/2026, have not provided the proper address in respect to the respondent numbers 4 to 7. Under such circumstances, on the question of maintainability of the present petition, list this matter for admission on 12th of August 2026.
I may be allowed to take dusty service, Your Lordship.
Nothing doing.
Authorized, Your Lordship.
IA दिसे थे बाकी नहीं दिया थे petition नहीं नहीं yes what is this case about
Lordship, IA is in respect of modification of the order.
what
So
order
if this order of the year 2011, 2021, Your Lordship,
Ah,
by that order, that the respondent, private respondent number 4 has been restrained from proceeding with any construction,
not make any further construction
Lordship.
with regard to the extension of his building without any valid legal written permission from the Dekiajuli Municipal Board.
Respondent number.
Do you have a valid legal?
Lordship.
Yeah. Then there is no bar.
No, but Lordship, I am not on that, Your Lordship, as on date. The matter may be disposed of, Your Lordship.
Okay, let us see that.
Lord, the
Mr.
board has not
Ganguly-
filed it.
Mr. Ganguly, come this
Yes,
way.
you
Let
come.
us see.
I can come.
That's fine.
Only because of the IA that.
Forget about IA. Let's hear on the matter.
Lordship. Lord, this, if your lordship has the order dated 20/09/2021.
I am on that. What is your case?
My case is that, my lord, this building, my lord, that is constructed by the private respondent, that was without any, my lord, valid permission. Now, my lord,
Permissions?
We have annexed it, Your Lordship.
Finished.
kindly see the order, my lord. That order
No,
says,
forget about that. I'm saying you say that there was no permission.
yes, and that is why, my lord, the
I have
counsel
done
appearing for the
we
government.
are to issue direction to physically survey, inspect the construction done by and to demolish the illegally in its entirety and further. Yeah. Now he has the permission.
Lordship,
His permission, my lord, that he has annexed, my lord, the submission by the government advocate on that day, my lord, when the order was passed, was that he has a permission, but the extension that he's doing is beyond, my lord, the permission.
Nothing. Go to the civil court.
Lordship.
My lord, civil court.
Go to
cannot-
the civil court. No, nothing doing. I'm not
Start.
going to it. No, you, it is purely a dispute between you and him.
Yes.
No,
This
my
is
lord,
not the court.
the board has to place its, my lord, the affidavit on record.
No.
That permission is a provisional permission, my lord. Lordship will kindly have for a
So
minute.
what? He has been allowed to construct.
No, he has not been allowed, my lord.
He has been allowed to construct.
41, my lord, page 41, it says it's a provisional permission, my lord. That is 6/4/2020.
There has been issued no objection certificate under clause 1 of section EA for construction of the Assam type RCC building, septic tank, so and so basement, ground floor, so and so, so and so, so and so. Yeah, the boundary wall is here, approved plan is this, construction done.
Yes. Lordship, so far the ground floor is concerned, we have already made construction.
Ah.
When the first floor was started, that in the year 2021, Lordship, this petition has been filed.
He's,
Number, second floor is provisional.
Yes,
You see the permission,
Yes,
second floor is provisional.
provisional.
So therefore it has the flavor of a provisional like.
Yes.
Who is paying for Dekiajuli?
telephonic instruction was taken on that date, my lord. Telephonic instruction was taken by the government council on that date. That was during COVID, my lord.
To close this step. You have a, and what, how are you agreed?
I am his neighbor, my lord.
So what? What is the problem?
The problem is, my lord, that it's an
You have
illegal
not
construction.
challenged the construction,
No.
the permission.
No, the permission, my lord, has come on record right just now, my lord, when they have
So
filed
what?
the affidavit.
They have filed. the
7 days
affidavit,
back,
so
how can
they
I-
had the permission long time back.
No, my lord. The board's council said that the extension is without any valid permission, my lord. That is why
There's
the
no
order was
board's
passed.
Council here.
Kindly see the order, my lord. 20th of September, my lord. It
You have
says
to challenge this permission.
that he has placed on record now, my lord.
So what?
On
Without challenging
7
the,
days-
you want to amend the petition?
I have to, my lord, this is filed 7 days back, my lord.
So what?
I have just come to know. How can I, my lord? I have to give it
That
given
is
some.
not then.
No, this permission is provisional, my lord. It is provisional. His extension was beyond authority, my lord. He does not have the permission for the extension that he was doing. That is precisely the submission that
Well,
was
what
made.
is he the constructing?
You know, he's constructing beyond what is permitted, my lord. That is why the board's
So,
affidavit needs.
so
to come
you
on
mean
record.
to say that you say that he is constructing beyond what is permitted?
Yes, and
So that means it presupposes that there is a permission.
that.
No, Mr.
permission-
Ganguly,
Lordship,
it presupposes that there is a permission.
there is a permission.
Have you mentioned in your petition that there is a permission?
No, my lord, we never knew. That
So
is why,
therefore, how are you saying that he is constructing beyond the permission?
my lord, the fact of the matter remains that the instruction was taken that, my lord, this permission, and this is provisional in nature, my lord. He has not annexed the final permission or
There's no
anything like that.
requirement of a final permission. This is the permission which is being done.
No,
Do
no,
you have
this-
anything?
Though there is an affidavit prepared, but it is yet to be filed on a behalf of respondent number two. It says, my lord, the permission is provisional permission and the extension, the extended construction that is beyond permission, my lord. Though
What
it is
the
not under
extended?
record.
What is the extended permission?
But if your lordship kindly go through it, it is yet to be on record, my lord.
Oh, how many floors you have constructed?
Only ground floor, lordship.
So you have given the permission for constructing ground floor and first floor.
Lordship.
Then
No, my lord, kindly see the photograph that I have annexed, my lord, at page 24 of the writ petition, my lord.
First floor is zero.
And the photographs that he has also annexed, my
page
lord. 24 onwards, my lord.
24, this one has nothing.
Yes, 24, my lords, left side is my building, right side is his construction building. There is absolutely no setback. He's right on the, my lord, he's right next to me. No setback at all. This cannot be the permission, my lord, granted. As per the permission, he's required to maintain at least the minimum setback. He's going on extending towards my side.
Side backs, right is 1 meter.
1 meter. That is the
And
minimum.
left is, you are left or right?
That, my lord, would.
You don't know.
My lord, how can, my lord, he is constructing with right next to my wall, my lord. These are
Only
the
your permission.
No.
lordship.
You may have transgressed into his land.
That is not his complaint, my lord. He has never said so
Not
before the board.
necessary. Why should we look into all these things? Go to the civil court.
Well, civil court, my lord, the Town and Country Planning Act and the Municipal Board Act, my lord, they bar the jurisdiction of the civil court, my lord.
Regarding?
My lord, the permission and the permission itself, my lord, the board has also said that the permission is, my lord, the extension is
So
without
you got
permission.
that affidavit. Good. Go there. Find it out.
Civil court would not have jurisdiction, my lord.
And they have asked them not to construct.
Then let him
Why
not
should we
construct, my lord.
entertain this type of
My lord,
litigation?
then let him not construct as per the board's direction. Because it is only pursuant to this court's order that the construction was stopped, my lords. The board did not interfere in the matter, my lord, till your lordships interfered by this order of 2021.
Hello, we vacate that order.
Lordship.
You go ahead as per the permission.
Lordship.
Is an interlocutory application filed by the respondent number 4 taking vacation modification of the order dated 29/2021 passed in WPC number 4539/2021. From a perusal of the order dated 29/2021, it is seen that there was a direction till the returnable date not to carry out any further construction by the respondent number 4 of the building without any valid legal written permission from the Digiyajuri Municipal Board, that is the respondent number 3. This court have duly heard Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, and Mr. R. Bhuiyan, the learned senior counsel assisted by
And Bhuiyan, lordship.
so and so, appearing for the respondent number 4. Post. From the materials on record, it is seen that there is a provisional permission which have been granted to the petitioner on 6/4/2020. There is no other permission other than this provisional permission, which is the submission made by Mr. R. Bhuya, the learned senior counsel, appearing on behalf of the respondent number 4. So consequently, the respondent number 4 can only be permitted to make the to carry out the construction on the basis of the provisional permission dated 6/4/2020. No further construction other than what is permitted in terms with the provisional permission dated 6/4/2020 can be carried out by the respondent number 4. This court further observes and directs that the pendency of the instant writ petition shall not bar the respondent number 4, the Dhekejali Municipal Board, to take action if there is a transgression to the provisional permission dated 6/4/2020. With above the instant petition, with the above observations, the instant application stands closed. In petition, that an affidavit in opposition has been filed by the respondent number 4.
Respondent number.
Four.
Were filed.
Yes,
Is for.
4. Full stop. The Mr. N. Das, appearing on the learned government advocate, submits that he has been instructed by the Dhekejali Municipal Board, or whom we are filing,
Two, my lord, deputy director, Passport Town.
behalf of the executive officer of the Dhekejali Municipal Board, to inform this court that the executive officer, Dhekejali Municipal, intending to file an affidavit in opposition. The same would be filed within 7 days. Stop. List this matter again on 7th of September 2026. The affidavit on behalf of the respondent number 3 be filed on or before 7th of August 2026.
Two, respond number 2.
Above the executive officer,
executive.
Dhekejali Municipal Board be filed on behalf on or before 7th of August 2026. Liberty given to the petitioner to file reply thereagainst, including filing reply against the affidavit in opposition filed by the respondent number 4. The said replies be filed on or before 21st of August 2026. Liberty given to the petitioner, respondent number 4, to file a rejoinder to the affidavit in opposition filed by the Dhekejali Municipal Board, if so advised. So on the next date, an attempt shall be made to dispose of the writ petition, which should be listed as in the admission column.
Because in the IA, my lord, lordships have said at one place, respondent number 4 board, my lord. That is wrong. Respondent number 3 board, my lord. In the IA, I think he has. Public.
My lord,
Yes, madam, why this is happening? Why you are not paying this 8 lakhs?
lordship, I will get the instruction, my lord. Notice has been served on 17/7. So
Was passed. I'm back.
yes,
2025.
yes.
Do you require filing of an affidavit, contempt? And then only you try to wake up?
No, lordship, so far I'm remembering the director has taken up the matter with me. They have written to the finance, I think. I'm not sure, I think, for release of the fund. I will get the instruction, my
There's
lord.
no question of, it's a case of refund.
Yes, sir.
Refund, my lord. Lordship, I will get the instruction,
Yes.
my lord.
It is seen that though the service is complete, the present contempt application has been filed alleging willful and deliberate violation to the order dated 10/6/2000, judgment and order dated 10/6/2025, passed in WPC number 6603/2025, whereby there was a direction upon the respondent number 3 and 5 to the said writ petition to refund the amount of rupees 8 lakhs 1
Yes, yes, your lordship.
to the petitioner upon service of the certified copy of the order. The certified copy of the order having been served, the refund having not been granted, the petitioner have alleged that there is a willful and deliberate violation to the order dated 10/6/2025, passed in WBC number 6603/2025. This court have taken note of that though the service is complete as regards the sole respondent, but the sole respondent have not put in their appearance. Consequently, this court have requested Ms. M.D. Bora, who was this is the standing counsel of the Transport Department, as well as who had appeared on behalf of the said respondent in the writ proceedings, to obtain instruction as to why the order dated so and so 10/6/2025 passed in WPC number 6603 have not yet been complied with. List this matter on 26th of August 2026.
Lordship, I'm
I'll
sorry.
give her a copy today itself.
Copy of the instant petition be served upon Miss M. Deborah, the learned standing counsel of the Transport Department during the course of the day.
Yes, Your Lordship.
The registry shall also show the name of Miss M. Deborah in the cause list.
I'm so deeply obliged. Lordship.
Deeply grateful, Your Lordship.
What it is I
Madam, Mr. J. Sharma is not well. That is why he couldn't come today, madam.
who wants to withdraw?
Petitioner number one, I think.
Huh? Petitioner number one. Withdraw. Okay. Let her withdraw. This number one wants to withdraw. This is an application heard Ms. So-and-so, Mr. So-and-so, the learned counsel appearing on behalf of the applicant. The so-and-so appears on behalf of the respondent numbers 1, 3, 4,
1, 3, and 4.
so appears on behalf of the respondent number 2. An application filed by the petitioner number 1 as the applicant to seeking leave of the court to withdraw himself or herself,
Himself.
withdraw himself from the accompanying writ proceedings. The respondents of the who has put on their appearance have no objection to the same. Consequently, the petitioner number 1, who is the applicant herein, is granted the liberty to is granted the leave to withdraw at the risk of the petitioner number 1 / the applicant. The I stands closed. The counsel appearing on behalf of the petitioner, main petition contribute, in view of the order passed in IA number 2334/2026, the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days. The registry shall, on the basis of the said memo of parties, make necessary correction in the cause style and update the same in the CIS. On main column. Main column, did you affidavit file?
No, my lord.
You are not filing your affidavits?
We'll file it, madam. We got
In
the
addition to
instruction,
that, this court directs, this grants a final opportunity to the respondents to bring on record their stand by filing the affidavits. List this matter again on 11th of September 2026. The affidavit be filed by the respondents on or before 31st of August 2026. Liberty given to the petitioner to file reply thereagainst.
I may appeal, Lordships. A matter relating to selection and election of the Gaon Panchayat president, my lord.
Why?
My lord, we are the six petitioners, my lord.
Challenge made in the writ petition is to the order dated demand passed by the court whereby the representation of the petitioner against the election and selection of the respondent number as president and vice president pursuant to the order passed had. Okay. Now why you are challenging?
My lord, 2/7/2025, my lord. First meeting was called, my lord. 2/7/2025. First meeting was called for selection and election of the president of Gaon Panchayat, my lord. On that day, my lord, a respondent, official respondent, ousted the petitioners, my lord, from the office where the election was held, my lord. On the very day, my lord, 2/7/2027, petitioner filed complaint before the Deputy Commissioner under Section 11 of the Panchayat Act, my lord. And again, my lord, 14/7/2025, petitioners filed a representation before the Deputy Commissioner. They did not do anything, my lord. Thereafter, my lord, petitioner approached this honorable court, my lord.
Why are you making so many people a party?
My lord, there is a private respondent, my lord.
8 and 9.
Yes.
Who is the president?
President, my lord, respondent number 8, my lord.
And who is vice president?
Vice President 9, my lord. And others are the member.
And why they have not filed the affidavits?
Was listed on 10/6, my lord.
Yes, you have to file. Why
Yes, yes.
PNRD is not appearing? Is the PNRD matter?
Yes, my lord.
Why PNRD is not
Upon
appearing?
And my lord, very interesting, my lord.
Very interesting. What is the interest?
My lord, court directed the respondent authority to dispose of the representation, my lord. Instead of dispose of the representation, my lord, respondent number 4 dispose of the reminder, my lord. A reminder which is submitted 25/3/2026, my lord. A impugned order is PS 68, my lord.
Hey, somebody had already put in the appearance notices upon respond number so and so by speed post. Usual process. Also has been received. Now, the question is, in 10, 11, 12, the service is not complete.
Already steps taken, my lord.
Has been delivered.
Yes.
Service is complete.
Service complete.
A service being complete, list this matter for admission on 7th of August 2026.
I cannot be prior to 7, my lord. My lord, there are the 4 persons ruled of.
Okay, admission be on 31st of August, July 2000.
31st of August. 31st of July.
That day we will consider passing of interim directions.
Yes, my lord. My lord,
The next day, this court shall consider. You have asked for interim prayer.
no, my lord. Sorry, my lord.
Have you asked for interim prayer?
Yes, my lord.
Okay, on the next day, this court shall consider as to whether any interim orders are required to be passed. Then they will come in.
God bless.
My
Yes.
lord, one IA is also filed as per the direction of the honorable court, my lord. It was filed on 17/7, my lord.
The last occasion, it was,
Yes, what is your instruction? I've asked from the revenue
yes,
secretary.
instruction, Lordship. The original,
My lord,
the original filing cases records are not present.
My
On
they don't double construction one.
report edition. Copy from.
So, the construction of, yes, Mr. Dutta, why you are not appearing when the PNRD matters are being taken up?
Sorry, my lord, I was in court number 1, my lord. I was just, but already
Anyways,
on 31, I will,
yes, I'll be passing in interim orders on the next.
well, appear on.
You affidavit,
Yes,
whatever. Now, meaning thereby that you have not disposed of the representation.
Not yet, Lord.
So therefore, there cannot be any construction.
Not.
Otherwise, it will be a violation. Somebody who appeared on the last occasion, government advocate
Yes,
N.
yes,
Gusam.
yes. Further
I
instruction.
still remember when the matter was taken up by me on the last day, it was said that it was a different plot of land.
Yes, yes.
Now, without disposing of the representation, how can you say that? When the revenue department categorically says in their instruction that they are yet to find out as to whether it is a private land or it's a ceiling surplus land. This is the instruction. The DC is not being able to provide the instructions to the revenue department, and they have been seeking it.
But my instruction says, my lord, as per records of right available in the office of the circle officer, construction work has been carried out in the land covered by the DUG number 26.
There shall be no further constructions. Otherwise, it will be in violation.
Yes.
We are concerned with DUG number 23. And DUG number 23 is outside this. Yeah, Mr. Fukon, your case is in respect of DUG number 20, 21, 24, 26, 29, 69, 71, 253, 75, 76, 101. Isn't it?
Yes, Lord.
You have nothing to do with DUG number 23.
Yes, my lord, it is annexure 1 and page number 15.
Understood.
Yes, my lord.
These are the DUGs.
Yes, my lord.
We are concerned only with your DUGs.
Yes, my lord.
And these are the DUGs which were mentioned out there in the order passed by Justice Surana,
My lord.
if I'm not wrong. Clear? Oh no, Justice Asimtamala Budhabu. Yeah, these are the DUGs. Kindly come to page 34.
Yes, 2021.
Yes, ma'am.
These are the DUGs.
20, 21, 24, 26, 29,
Please not there.
69.
No.
Yes, ma'am.
They say the construction is being carried out in 21. 23.
Madam,
Okay, it's okay. We do one thing. We, they have sought for 8 weeks time
Yes, Lord.
for disposal of.
Madam.
There shall be no construction in these DUGs because this is the direction. When the revenue department categorically mentions that there is no, that they have not yet disposed it of or
Yes.
don't have records
Not.
and they are taking up with the deputy commissioner. So therefore they have sought for 8 weeks. We have it in the month of October.
Not.
In the meantime, let them dispose of the representation and
Madam.
and not to carry out any construction. in this.
My lord.
This court by an order heard Mr. D.C.C. Fukon, the learned counsel appearing on behalf of the petitioner, Ms. G. Toika,
For respond number 1.
who appears on behalf of the Revenue Department of the Learned Counsel, who appears on behalf of the respondent number 1, Mr. Endas, the Learned Counsel, who appears on behalf of Learned Government Advocate, who appears on behalf of the
4, 6,
District
and 8.
Administration. Mr. So-and-so, who appears on behalf of the PNRD Department.
3, 9, and 10.
This court, by an order dated 13/7/2026, sought an instruction from the Revenue Department as to whether the representation dated 4/1/2017 submitted by the petitioner have been considered by the Revenue Department as was directed by the learned coordinate bench of this court in the order dated 8/3/2017, passed in WPC number 1341/2017. This court finds it relevant to take note of the directions which were passed by the learned coordinate bench in the order dated 8/3/2017, and the relevant portion thereof is reproduced here in under page 35 on last line to in terms of repetition discourse. Is the 6 hours. Today, Ms. G. Hazarika, the Learned Standing Counsel of the Revenue Department, had placed before this court an instruction which had been issued by the Secretary to the Government of Assam Revenue and Disaster Management Department, dated 18/7/2020. The said instructions collectively are kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that the Revenue Department do not have records as to the disposal of the representation dated 4/1/2017. And the Revenue Department therefore have sought for some time, preferably 8 weeks, for the purpose of taking necessary steps. Consequently, this court grants 8 weeks time to the Revenue Department to duly take steps as regards the representation so submitted by the petitioner dated 4/1/2017, and place an update before this court on the next date. This matter on 2nd of November 2026. In the meantime, it is categorically observed and directed that there shall be no construction be carried out in the land at measuring 59 bighas 2 kathas covered by dark numbers 39 of KP Pata number 10 of Revenue Village, Hazongbori, Panbari, Moza, Kamrup, till the next date. Okay.
This is a writ petition filed by the APDCL, my lords, impugning an order passed by the appellate authority, my lords. The issue facts are otherwise are with regards to allegations of theft. The meter was found to be tampered. For this very reason, my lords, perhaps the records would be necessary. May I be granted a week's time to produce the records, and in the meantime, I shall also file my reply, my lords.
Do you want the stay?
There is already a stay operating, my lords.
What about the interest?
That would perhaps be, my
They
lord.
would be subject to interest.
What's a week's time? Sometime next week, my lords, I'll produce
No,
everything.
this is a matter of 2024.
Yes.
Oh, no. 2 years. Getting a stay.
That would perhaps be something.
Subject to interest as on that day. Regulation 10%. What is the interest?
16%.
How much interest do you impose if there is a delay?
The amount has already been deposited, my lord. The direction of the appellate authority is to refund the amount.
Understood.
The period has been reduced.
So therefore, if
That
there is
would-
a delay, how much interest do you take?
I do not have instructions along those
No,
lines.
you have. That's
Them.
statutory. Same interest here.
That would be, again, my lord, subject to the outcome of the writ petition. Yes, ma'am.
If you win the case, no nothing. If you don't, that is, this court extends the interim order only with that condition. That will be payable, interest will be payable as per the rate at which you would have charged if there is a delay.
Very well.
The rate is already prescribed in the regulation.
How much?
16% per annum compounded every 6 months.
Very well.
Heard Mr. B. Chaudhary, the learning counsel, appearing on behalf of the petitioner. Why the matter has come up for admission?
For orders, my lords, the respondent number 2, we varied the respondent number 2 is the appellate authority. Otherwise, sorry, respondent number 1. Yes.
We have the respondent number 2 every question.
It has come up for orders. No rejoinder filed by affidavit filed by the petitioner till date. Okay. Oh, you wanted to file a rejoinder. You are not going to file.
Well, I'll file it within a week's time, and I'll also
10,000?
produce the records. my lord.
Cost of 10,000?
If necessary, my lords, I'll file it, my lords.
with the cost of death.
I had sought certain documents, my lord. Those are not yet received.
Because they have filed the affidavit on 16th.
Yes, yes, my lords, I'm aware of that.
Anyway, you are going to pay interest with the rate, so there's no problem. We have it after 2 years.
It's sometime next week, my lords, I'll
The
get all the.
affidavit has, the rejoinder affidavit has not been filed by the respondent number one, by the petitioner.
Petitioner, my lord.
So time was sought for on 3/6/2026. It is relevant to take note of that the affidavit in opposition was filed by the respondent number one on 16/12/2025. Mr. D. Sonepati, the learned counsel who appears on behalf of the respondent number one, submits that the interim order passed earlier should not be further extended as the petitioners are delaying the proceedings on one hand, and on the other hand, there is a stay order operating whereby the petitioner, the respondent number one, have not been granted the refund. Full stop. Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL, submits that a final opportunity may be granted in that regard. Full stop. Taking into account the interest of justice, this court grants 4 weeks.
Well, it's a week's time, 28th something.
No date fixed. Interim orders to continue till the disposal, subject to payment of interest as per the rates. He says he's also
Well, sometime
instead
next
of
week, I'll
keeping
get the
it in
instructions,
the
my lords.
bank,
My lords, we
he
can.
gets 16%.
16%, 6-month compounded.
He's happy.
May I only pray for a fixed date, my lords?
No. Why should I? We should not. We have not, you have been granted the time.
My lords, I am aware of that, my lords. There's a
In the above, comma.
only one opportunity, sometime next week, my lords.
This court, though is inclined, considering the above, comma, in the interest of justice, a final opportunity is granted to the petitioner to file the rejoinder within 4 weeks. It was also, this court also takes note of that the interim order, though passed, the interim order which has been passed does not contain a condition. It is well settled. An interim order is passed, there is a requirement of imposing certain conditions. Accordingly, this court imposes the condition that in the circumstance that the interim order shall continue, subject to the petitioner would be liable for payment of interest at the same rate at which they would have charged in case of default by the assessee. With the above conditions, the interim order stands extended until further orders. Is the matter for hearing?
My lords. My lords, yes, yeah.
Until further orders. The week's time in it. Business matters for petition on 23rd of September 2026. In the meantime, the petitioner would be at liberty to file the reply.
Deeply well.
Very good.
May I please? This is the IA for implementing the new incumbents in the contempt petition, my lord. As a respondent number 3. Earlier, Principal Secretary has been transferred from the post of Principal Secretary BTC, my lord. Now the new Principal Secretary has went. And this is the second round of the IA. Earlier, IA was been rejected by this honorable court, my lord. And thereafter, I have the liberty to submit a fresh representation before the principal secretary. Now, I have submitted a fresh representation, that is page number 22, my lord. The BTC. He is not here. Just now he is telling me. Want to make whom a party? Mukesh Chandra Sahu, my lord, the present principal secretary. Mukesh Chandra, that is respondent.
Petition filed for impleading the present incumbent, Principal Secretary, Boroland Territorial Council, to the accompanying contempt application. So taking into account that for the purpose of with the accompanying, the present incumbent is to be brought on record. Present incumbent holding the post of the Boroland Territorial Council is required to be brought on record. This court includes the Mukesh Kumar Chandra Sahu, IS, Principal Secretary, Boroland Territorial Council, Pokrajar 783370, as the respondent number 3 to the accompanying contempt application. IS, counsel for the petitioner is directed to file a fresh parties before the registry of this court within 7 days. And the registry shall, on the basis of the fresh memo passed in the instant application, make necessary correction in the cause title and update the same in the CIS. IS stands allowed. To notice upon the respondent number 3. Steps be taken by way of returnable on 25th, 2026. Be taken within 3 days to submit accordingly. Item number 15 also same, my lord. Yeah, it would be respondent number 4. my lord. Item 15. Same respondent, same case, and as a respondent number 4. Deeply obliged. What has happened in the meantime in this case?
No. 16. The land in question is still a PGR land, my lord.
Mainly it is PGR would not, because in 1953 you have those, you have issued annual patta to these people.
Then that's true, my lord, but page 96,
What is that?
para 7, my lord.
Understood. No quarrel with that. But in 1953, there was a move at that point of time to remove this PGR and all, reserve and then grant patta. And in pursuance that too, you have granted pattas long time back.
No, but
Pattas have been issued sometime back in 1944.
the record says it's still in PGR, my lord. And
Maybe. But what steps have been taken by the revenue?
that's also not clear. It says it is not clear what are the subsequent
Yes,
steps.
revenue. What do you have to say? You can use your mic there. There's a mic, I've got it out there. This is not for the district administration alone, because here these pattas have been issued in 1944, annual patta. They only asked that, okay, now kindly confer it, make it permanent.
I'll take instruction, my lord. Our name is going to be shown, my lord, so I don't know. The cause list, my lord. So
Revenue? Post.
the cause list, my lord.
Huh?
The cause list, our name is going to be shown.
Revenue is there, respond number 1. Respond number 2, revenue.
Next week, my lord, I'll take instruction.
None appears on behalf of the petitioner on call. Mr. Endas appears on behalf of the respondent number 4, 5, 6, and 7. 4, 5, 6.
4 and 5, my lord.
4, 5, and 6. Mr. Mohanta appears on behalf of the respondent number 1 and 2.
BDO, a circle officer, 456.
Appears on behalf of respondent numbers 1, 2, and 11 with petitioners have joined together to seek that, thereby seeking directions upon the respondent authorities. Grant patta to the petitioners. Whereupon their predecessors were granted annual pattas as far back as in the year 1944. It is also taken note of that way back in the year 1953, there was a move on the part of the respondent authorities to de-reserve the Kharpuri PGR comprising of around 800 bighas. This court have also taken note of the affidavit which has been filed by the respondent number 4, wherein it is categorically mentioned that these communications which were made as far back as on 3/6/1953 wherein it is categorically mentioned that though approval for de-reservation of the PGR land was recommended by the government in the year on 3/6/1953, but there is no records available as to what subsequent steps were taken for de-reservation by the then subdivisional officer Mongoldoy, inasmuch as the land is still recorded as PGR in the land records. It is the opinion of this court that the stand on behalf of the respondent numbers 1, 2, and 3 is required, inasmuch as the said respondents would be well aware about the steps which were taken by the government for de-reservation of the land in question. P.R. Mohanto, the learned standing counsel of the Revenue Department, submits that she would obtain instructions and file an affidavit. This matter again on 25th of September 2026. In the meantime, the affidavit be filed on behalf of the Revenue Department on or before 23rd of September 6. Registry shall show the name of the P.R. Mohanto as the standing counsel of the PNR of the Revenue Department in the court list.
Lordship, though it's a matter of 2018, Your Lordship, the issue involved here is that the Janai Simalu village falls under the notified area that has been declared as sanctuary or not.
Huh? What are you challenging?
Lordship, the challenge,
Being a
Lordship,
second portion
Lordship,
of the
lots of water has
petition
flown,
issued
Lordship,
by
in the
the
meantime.
Forest Department, declaring and adjudging the same to be unconstitutional. What
Lordship,
is this
lots of water
notification?
has flown, Lordship, in such years, Your Lordship. Lordship may come to the affidavit, Lordship, that they have filed on 19/11/2024. The core issue has been, the only issue is that we are the residents of the Janai Simalu NC village. Lordship may come to page 55. And para 2, Your Lordship, that the present writ petition has been filed alleging non-adherence so and so while declaring notifying Amsang Wildlife Sanctuary, which is situated in the vicinity of Gauhati. It is further contended by the petitioner that the village Janai Simalun NC, of which they are the permanent residents, does not fall within the boundary of the said Amsang Wildlife Sanctuary. It is also pleaded that no exercise of acquiring and hearing as mandated under the laws was ever conducted. And Lordship may come to para 4, Your Lordship, thereafter. What have they done, Lordship? They have started rationalizing, keeping in view, rationalizing the area, Your Lordship. And regarding that, Lordship, on last date, Lordship, instruction was sought from the Forest Department, Lordship, and the instruction is still awaiting your Lordship. Para 4, Lordship. 10th line.
He's saying that
The state board,
Forest Department, the counsel for the Forest Department still is absent today also. On 3/12/2025, when the matter was listed, there was also no representation from the Forest Department. Considering the above, this court also duly takes note of that there is an interim order since 2018. And the Forest Department appears to be not concerned. Considering the above, this court directs the registry to issue a communication to the Commissioner and Secretary to the Government of Assam, Environment and Forest Department, as to whether and so that to apprise this court so that instructions be placed by the Forest Department as to whether they are interested in the present proceedings. List this matter again on 6th of November 2026. Same orders passed earlier shall continue with the disposal of the requisition.
much obliged, Lordship.
Yes.
I'm appearing for respondent number 3, Down Refinery, Indian Oil Corporation.
Still,
Ayushil Lordship,
there is not a party.
no party. Name shown. Name shown.
Now,
SCIUCL.
what has the state done as regard this? IOCL is a party. You are IOCL.
Yep. The unit of Ayushil. On last occasion, Lordship, petitioner takes time for has already expired lawsuit.
The present petition has been was filed. But the petitioner seeking certain compensation. Petitioner had expired as was placed before this, and this fact was placed before this court on 19/9/2025. Petitioner. The counsel for the petitioner thereupon sought for instructions for taking steps for substitution. However, the substitution have not been carried out. And almost 10 months have already expired. 10 months have already expired. Considering the above, in absence of the petitioner being substituted, the present writ petition cannot be proceeded with. Accordingly, the writ petition stands closed as the present proceedings has abated.
We have instruction, my lord, which my lord, status report as on 19. Lordship.
7/8/25. But I take it your orders passed on 7/8/25.
What are you asking for, Mr. Biswas?
We have, 11/8/25 as of my lord. Later we have received. My lord, 11/8/25, my lord, the status report of 11/8/25. They 6 my lord, 6 months further, they sought my lord, further 6 weeks time, my lord, 6 months time.
What happened after 1 year?
My lord, I will have to take my lord up to date instruction, my lord. It is of 19/25, my lord.
When a matter was listed before this court on 8/9/2025, an instruction was placed which was kept on record and marked with the letter X. Perusal of the said instructions dated 6/8/2025, it appears that investigation or inquiry was being conducted as regards the disproportionate assets of 12 numbers of suspected officers. Almost a year have passed by, and an updated instruction would be necessary for the purpose of disposal of the present proceedings. It's the matter on 31st of July 2026. In the meantime, an updated instruction as regards the inquiry be placed before this court by the respondents without fail.
Madam.
The
My lord.
preference of the petition, my lord. What should turn to pin now 47. He has filed a application for regularization. The petitioner has filed for an application for regularization of the particular building. And that is pending consideration, my lord. Lordship will post it after 4 weeks. In the meantime, it will be done. The building is standing without any permit. Only the though it comes within the GMD area, Gauhati given the NOC without getting without any NOC, without any pending permit from the GMD.
My lord, in compliance with order dated 9/3/2026, we filed an application before the authority.
9/3?
9/3/2026.
When did you file?
We filed on 25/3/2026, 25 March, we filed application.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that in pursuance to the order passed by this court on 9/3/2026, on 26, the petitioner had submitted an application.
My lord, we filed application on 13, but
on
affidavit on, we filed an additional affidavit here on 25 March.
My lord, he had filed the application for regularization on 13th March 2026.
13th March.
13th March 2026.
Submitted an application on 13th March 2026 in terms with bylaw 18 of the Gauhati Building Construction Regulation Bylaws 2014. As per the learned counsel appearing on behalf of the GMDA submits that the same is under consideration. Considering the above, list this matter on 27th of November 2026. Interim orders passed earlier shall continue till then.
Always, ma'am.
Yes, what is this?
My lord, in fact, also this matter was actually heard by a coordinate bench on by this honorable court, my lord. After hearing, my lord, I was directed to file an additional affidavit, my lord. As in the court whether the original medical bill was approved by the government, my lord. But from the by filing our affidavit, my lord, we have this the honorable court, my lord, that this original bill was also not approved by the government, my lord. So accordingly, that medical bill rules, my lord, cannot be a statutory rules, my lord, which the provisions of which could be executed before the honorable court, my lord. That order, my lord, order was passed, my lord.
I have passed an order on 16/8/2024.
That also we have filed our affidavit, my lord.
What does it say?
There is no any approval, my lord.
And
there is no approval, my lord.
And in that case, whether it is permissible on the part of the board to change the service conditions of an employee during the period of that is in service or even post is where they were affecting in view of clause 20 of the act stipulating the board shall with them. Without the approval of change this weather which was made with the approval of the government. And so that para you have provided. Him to trace out any order to give the as the respondent will just think. To answer the query in the tip. So there was a direction on 14/5/2026. What happened thereafter? Additional affidavit filed by respondent 2, 3, and
Hello.
4.
That was already we
What
have
do you
filed, my
say
lord.
now?
Next order is, my lord.
That order I have seen.
My
I've seen the order of 14/5/2026.
14/5, my lord, 14/5/26, my lord.
May regulate.
To that effect, my lord, we have already filed our affidavit, my lord.
Yes, Mr. Counsel, what do you say about paragraph 7 of the affidavit?
My lord, which affidavit? Third one or second one, my lord?
Last one.
Last, my lord.
It was filed on 19/6.
Well, in this regard, my lord, would kindly perish the page number 55 of the writ petition, my lord. That order was not attained finality because of, at that time, we have not challenged the office, board's decision, my lord. Only we have challenged the notification, my lord. Since notification was issued on the basis of board decision, since we have not challenged the decision of the board, my lord,
I get this order 6512 of 2015, that order 7/2/2017. Then four.
Yeah, 110, my lord. Last part of this order judgment, my lord. Passed in the earlier petition, my lord. That was the second round of litigation, my lord.
In such view of the matter, no information. For the subsequent. proceeding. So pursuant to this, you file a representation.
representation,
And thereafter you file a representation.
my lord.
So the last paragraph of therefore, the last paragraph, paragraph 7 of your affidavit
My lord,
of 19/6/2000, no value.
my lord.
Now therefore, the question is, the decision which was taken on 27/7/2011
My lord.
was a decision by which you are now going as per the CGSE.
True. My lord.
It is the case of the petitioners that who could not have changed the rules by adopting the Assam alia without an amendment to the rules of A. Is that the case? A order which I have passed. Please see. Order 16/8/2024. We come to paragraph number 3.
Well. Well.
Question therefore arises, in view of the respective submissions made by the learned counsel appearing on behalf of the parties as to whether the Board of Trustees could have taken a decision in the meeting held on AIA, which was thereupon notified by the office memorandum dated AIA without amending Rule 11 of so.
Well,
Is the sole.
well,
You amended.
that then there was no any amendment, only the decision was taken, my lord.
Oh,
to adopt the
rule 11 continues
Well.
to hold the field. Let us see Rule 11. Where do we find that Rule 11?
Let it on record, my lord, already.
Rule 11, my lord, that is that it relates to cost of medical, medical attendance and treatment, my lord.
Where do we find the rules?
My
What are
lord,
the rules?
that were not annexed but supplied, that is with the record, my lord. Well, I have a office copy, my lord.
But the fact remains That econ sounds soon, Nama. Then fund and pension.
My lord, actually, this original rule also not, it was not approved by the government, my lord. That we have said in our affidavit.
It was not approved.
Not approved, my lord.
Let us see. Some people. Provident Fund and Pension Fund Scheme 1960. क्या किया था? ये है that book?
My lord.
The board shall, with the approval of the government, make regulation regarding recruitment, pay, allowance, discipline, superannuation benefit, and other conditions of an employee. The approval of the government.
Right.
Are you saying that these medical rules were made without the approval?
Without it. That we have said in our affidavit, my lord.
My lord,
In our, this additional, this affidavit,
my
my
lord,
lord.
they have filed the third affidavit, my lord, on the basis of their personal knowledge, not with record, my lord. They have filed the earlier affidavit, second round additional affidavit, my lord, which your lordship will find,
On the 19.6,
my lord.
they say,
In para 4, my lord, in our, this present edition affidavit, my lord, we have said, my lord.
steadily were not approved by the state government
Yes,
as
state government.
required under Iman and constituent, therefore, so under no surrender could be treated as statutory rules.
Well,
the provisions of which would be enforced in the court since inception, therefore, the same was used as a guideline.
Well, before that, your lordship carried the earlier affidavit, additional affidavit filed on 4/11/24.
Paragraph 4. The 4 is based upon to by best of
Knowledge, my lord.
How can you say on knowledge? It has to be based on records. The search the records and records there is no approval. Because this particular person who is joined it, these rules were made in the year 1968.
83.
86, my lord.
You are part of this. Couldn't have been a part of it. Person concerned, the joint of Chiang Mai. He could not have been a part of it. How could he have said out here on affidavit that this is true to my knowledge? Earlier, what does it say?
4/11/24, my lord, they have filed second round additional affidavit, my lord.
Yeah.
Pair numbers
That
6 and 7.
Of the government make regulation regarding that the office attempt to trace out any order of to give approval by the state government to the aforesaid demand as required, but they have totally failed to trace out the same as the same pertains to the year 1983. Formal approval given by the state government to the aforesaid so and so, but the said rules cannot be ignored. Right. And or thrown to the basket as the board of trustees is composed of the honorable minister so and so, so and so. So on paragraph 7, you say that this is most important. And in paragraph 4 of the new affidavit, you say that it is merely a guideline. Isn't it?
That, these are original medical rules, my lord. As it was not approved by the state government, my lord.
Paragraph 7,
My lord.
you categorically mention that these rules are very important. But at paragraph 4 of the recent affidavit, you say that these have nothing. So whether it has the approval of the year, we have to find it out from the government Ministry of Labor. we get the instructions from them.
Well,
whether the records will be available, I think they.
I will try to procure, Lordship. If it is available, they will furnish.
Because this, whether it has been approved, first of all, you could not have made anything without the approval.
That is up to him.
And if he has no approval, then it has nothing.
No, since they are enjoying that benefits, my lord, that there is no dispute, my lord. Even they want to change after my retirement by making a decision, my lord, just must be approved, my lord. Entire life, service life, my lord, we have enjoyed that benefit. Even after retirement, we are enjoying, my lord. Even at the time of service period, they have collected PF contribution, some others contributions, my lord.
Understood, but what will happen to the impact of the
Even
rules?
legitimate expectations
That
is there, my
rules-
lord.
the
I am
rules
enjoying that.
see, the rules could have been made only with the approval. But these rules, if it has been made without the approval, then what happens?
But that we are procuring this benefits, my lord. All of sudden, that cannot cartel. They have taken board's decision. First of all, in that board decision, Rule 11 was never placed, my lord. If we take see a decision, my lord, there are, that rules were not placed for amendment or modification, my lord. First of all, my lord. And without placing that rules or taking any decision about the rules, my lord, and thereafter, they have also not taken approval, my lord. First of all, the rules.
Well, it's okay. Subsequent approval is required. But if the rules were made without the approval, then what happens?
But rules itself say, my lord, that will come into force by with immediate notification, my lord. Minutes deal by deal notification. Somewhere there is a notification.
Such date, the competent authority may notify.
Notify. Obviously, that was notified, my lord.
How do you know?
Because of after before notification, how they implied, my lord.
No, because of this would not do. They categorically say this. Let us get the instruction from them. The government, the AI is there, huh? Who is the party?
Lordship, respondent number 1 is there, Labor Department.
The present petition challenges the decision of the Board of Directors dated 27/7/2011. It is relevant to take note of that on 16/8/2024, this court put a query upon the respondent numbers 2, 3, and 4 as to whether the prior approval of the government was taken for amending Rule 11 of the Assam Tea Plantation Provident Fund and Pension Fund Employees Medical Benefit Rules 1983. For short, the rules of 1983. Pursuant to that, an affidavit has been filed. Affidavit was filed.
Additional affidavit, my lord.
On 4/4/2024, wherein at paragraph number 6, it is mentioned that whether the approval of the state government was taken could not be traced out. Be that as it may, at paragraph number 7 of the said affidavit, it is categorically mentioned that the rules of 1983 cannot be ignored or brushed aside and or thrown to the basket as the Board of Trustees is composed of the Honorable Minister, Labor and Employment, etc., of the state government and chairman, the vice chairman and other 4 government officials are nominated members of the state government. And that amounts to giving implied approval to the aforesaid medical bills. Pursuant to the filing of the instant writ petition, the writ petition was again taken up by the learned coordinate bench of this court, or pursuant to the filing of the said affidavit, the petition was again taken up by the learned coordinate bench of this court on 14/5/2026, wherein the learned coordinate bench observed that the respondent number 2, being a statutory body, has to answer to the queries raised by the court in a more definitive manner. And accordingly granted 2 weeks' time for filing the affidavit. In pursuance thereto, and another affidavit has additional affidavit was filed on 19/6/2026, whereby the respondent number 2, 3, and 4 now states at paragraph number 7, paragraph number 4, that these rules of 1983 were approved by the state government as required under para 20B of the Assam Tea Plantation Provident Fund Scheme 1968. And they are now to be used, they are therefore to be treated as mere guidelines. Having no statutory force. It appears from the stands which have been taken by the respondent numbers 2, 3, and 4 in the affidavit so filed before this court on 4/11/2024 and 19/6/2026. As regards the rules of 1983 are different, inasmuch as the stand which was taken on 4/11/2024 was that the state rules should be deemed to be rules of 1983 should be deemed, if there is no specific approval, should be deemed to have the approval of the state. Whereas now, in the additional affidavit filed on 19/6/2026, the stand taken is that the rules of 1983 do not have any statutory effect and are merely guidelines. This aspect touches on the rights of each employee of the respondent number 2, 3, 2, right from the year 1983. And therefore, it is the opinion of this court that the stand of the respondent number 1 should be brought on record as to the effect of the rules of 1983 And further, as to whether there was any approval or even a deemed approval. So-and-so who represents the respondent number 1 submits that he would obtain instruction and file an affidavit. List this matter on 11th of September 2026. The affidavit be filed on behalf of the respondent number 1 on or before 9th of September 2026.
One thing I'm pointing out, Mala, in case of board of directors, Mala, it should be board of trustees, Mala.
You give better copies, Mr. Counsel. Take these and give us next. Because Mr. Das, this has the moment you are saying this, will have cascading effect upon all employees. As of now, those employees also. Because you don't have any other rules.
Let us see, Mala.
Yes, Mr.
My lord, in this case, this writ petition is for, my lord, non-payment of bills, my lord.
From whom?
Actually, my lord, the petitioner was appointed as a recovery agent by the bank to recover a loan. And a recovery was made and the bill was also submitted. That bill amount has not been paid till date. That is the sum and substance of the case.
Why have you not gone to the civil court?
No, my lord, there is no dispute as such because bill is raised as per bank's guideline only.
Then?
So there is no.
Paying for the bank?
Lordship, I am appearing for the bank, Lordship. This bank has been merged with Punjab National Bank, Lordship. Thereafter, we have communicated with them, but Lordship, instruction is awaited, Lordship.
You have to make the Punjab National
Yes,
Bank a
madam,
party.
I'll make party.
Mr. So-and-so who represents the respondent numbers 1 to 4
Yes, Lordship.
submits that in the year?
In the year 2022, Lordship.
2022.
Yes, Lordship.
The United Bank of India would merged with the Punjab National Bank.
2022 communicate first. We have communicated with the bank, Lordship, in the year 2022, Lordship.
And as such, for the petitioner to obtain necessary any relief, the Punjab National Bank has to be made a party to the present proceedings. Mr. M. Kotoki, the learned counsel appearing on behalf of the petitioner, submits he would obtain necessary instructions and, if necessary, file applications.
No, I'll file application, madam.
Shall submits that he would file applications seeking impleadment. Matter only upon such applications are filed.
Earlier, last.
No problem.
No, this is a matter we are challenging the order dated at page 6061. We are challenging the order dated 13 May 2020.
What happened to mediation?
Mediation failed. We have appeared in the mediation duly, Lordship. At the same time, when the ADC was called for, in the joint session, they came up, but thereafter they did not show up, Lordship.
The mediation failed.
Mediation failed.
What is your case?
Also, we are challenging the order dated 13 May 2020 issued by Joint Secretary to the Government of Assam, where illegally and arbitrarily they are passing the order, trying to attempt to evict the petitioner from the possession of the land below certain plot of land.
You're challenging some allotment letter.
Yes, Lord, sir. At page 6061.
So all pleadings are complete.
Pleadings are complete. They have filed the affidavit. We have
Taking
filed
into
the
account that the pleadings are complete and the matter would take some time. List this matter for final disposal on 3rd of September 2026.
Also here, still the talk of compromise is going on. Still talk of compromise is going with the government machinery regarding for alternative arrangement, Lordship.
Also fixed it for final disposal.
Much surprised.
One, I was thinking if your lordship can dispose of in the light of the judgment passed by this honorable court at annexure page 60. Because permission was granted for 3rd floor, he built 4th floor, and it was sold with the permission of the authority. And A similar case, my lord, your lordship directed that if you have given a revised plans, page 60,
16.
Here also instead of fourth floor, he made fifth floor and he has submitted a revised plan. Court directed that you consider the revised plan and accordingly action would be taken. And the present case, instead of, he got permission for third floor, but he constructed admittedly, my lord, fourth floor. And permission was granted to sell the plan, sell the fourth floor. And he has submitted a revised drawing also. That is not being considered.
Who is appearing for the Silchar Municipal Board?
Normally,
And who is respond number 6 and 7?
notice served, my lord.
Senior
But is appearing?
Toto appears not for me.
Service is not complete. Yes, you have Mr.
CC
CC
Datta
Datta,
appears,
doesn't he appear?
Normally he appears.
Service
not
in
as-
response to-
Name has not been shown in the process. Whether we
No,
have filed
obviously, the service is not there.
21. I'll inform him, Mr. Doctor.
Inform him and ask him to come at 2. Yes.
Your Lordship, in this matter, we have not received the copy yet, and also the cause list does not show our name. So, Your Lordship.
Anyways, obtain instructions in the.
I'll give.
The S. Datta, who is you are the standing counsel?
I'm not, my senior is standing.
The S. Datta, who assists, what's the name?
Siddhant Datta.
Siddhant, the learned counsel who assists Mr. CC Datta, the learned senior counsel, who is also the standing counsel. Silchar Municipal. That and by file an affidavit. List this matter again on 9th of September 2026. Meantime, the Silchar Municipal Board shall bring on copy of the writ petition be served conductor.
Obliged.
It is.
Lordship, there is a matter seeking compensation for acquisition of land. In the last occasion, some committee was formed to assess, because the Karbi Anglong said that this plot of lands where D reserve and pattas were issued, whereas the national highway says it is a forest area. Thereafter, a committee was formed. It is reliably learned that a committee has given its report. Now further action has been taken so that Karbi Anglong can.
Your Lordship, my senior is on his way. Kindly, my senior is on his way. I have informed him and he is on his way now.
What about the NHIDCL?
In the morning half, Talukdar was here, council. NK Talukdar, RK Talukdar was here in the morning half.
Yes, Mr. Sutia, what instructions?
My lord, there is a meeting with the Chief Minister, Chief Secretary with the NSIDCL, my lord.
And in the latest development, they asked us to furnish my lord to tell what is the compensation amount. And that amount has already been communicated to the revenue department, my lord. And we have already filed an affidavit, my lord, last affidavit, my lord. And now the problem is only in respect of the, my lord, deposition of the amount by the NIDCL, my lord. And 5 or 6, my lord, the petitioner, they have already 3A, 3D notices has already been published, my lord, in respect of the 2 villages. Those who have reserve villages notified in the Assam Gazette, and the other 299 acres, those where there is no Gazette notification, but there is a direction from the government in 1971 to settle the people, my lord, those peoples, and it is only pending for that purpose. And for that purpose, now that Dokmoka bypass, only 3 kilometers that has not been completed. In the other portion has already been completed. We have already issued the notification allotting the land in the name of the ministry, my lord. If you lordship look into the page 337.
Yeah. From Doboka bird and then connecting road where you have a
My lord. Only that stays, my lord.
Dokmoka.
Yes, my lord. That stays, my lord. That bypass has been blocked, my lord.
The bypass construction is all.
That has already been covered, my lord. Only the within that, my lord, 2 kilometers road has not yet been constructed in respect of these 3 villages. For that purpose only, my lord, whole project has not yet been completed. If your lordship look into page 337.
No, it's okay. Now, Mr. Bora said that there is some reports already submitted.
My lord.
28.
Now, what is your instruction, Mr.
Lordship, as per my instruction, lordship, now the revenue.
Yes, no. You use the other mic.
My lord.
There's another mic out there.
Oh, sorry, sir.
Yes, use that.
Lordship. Lordship, now matter is placed before the revenue department, lordship. So revenue department will place the action taken report to the Karbi Anglong authority, then we will, lordship.
A and 3D.
Yes.
A has happened or not?
No, lordship.
A have not happened. Till now, competent authority have, the central government have not issued that notification.
No, lordship.
But you have taken possession, no.
No, lordship, 1.5 kilometer road is now only, lordship, remaining, lordship.
So we adjourn this matter for some time being.
My lord.
A bit after 2 months.
My lord, now we have, my lord, nothing, my lordship, now matter is under the revenue department, lordship. We have already, my lord, placed the.
How does the revenue?
Yes,
department
yeah,
see?
because lordship, there is a minutes of meeting held with the chief minister, lordship.
Maybe.
Yes.
Here, the central government appoints a
Salah.
competent authority.
Yes.
Competent authority will initiate the process. Once he initiates the process, thereupon the central government will issue a notification under section 3A.
Yeah, lordship.
Then 3C, which will be looked into by the competent authority. Then 3D.
3D, lordship.
So it is, all these things have to be done by the central government
Lordship.
in concert with the NHIDCL.
Yes.
And the competent authority.
Lordship, yes.
How does the revenue department come into
Because,
this?
lordship, there is a meeting with this honorable chief minister, lordship, and in that meeting, lordship, chief minister have directed the deputy commissioner Karbi Anglong to place the matter before the revenue department, lordship. Now, Karbi Anglong department has already forwarded the recommendation, and now matter is with the revenue department, and they will place before the Karbi Anglong authority, then Karbi Anglong authority will place before us, lordship, and we will
How does
deposit the compensation.
Tell me one thing. If the land falls within the Karbi Anglong department, Karbi Anglong Autonomous Council, the land is with the Karbi Anglong.
Yes.
How does the revenue department have any say out there?
Lordship.
My question is, how does the revenue department will have a say, taking into account that it's a 6 area?
Yes, lordship.
And as per paragraph 3, it is absolutely within the domain of the Karbi Anglong Autonomous District. Isn't it, Mr. Sudhir?
Well, yes, my lord. But my lord, what happened in the meeting, my lord, also, in the presence of the managing director, NICDCL was present in the meeting, my lord. We were also present, my lord. Our representative was present. The amount that there was a direction that what is the total land compensation and Zirat is required to be surveyed. Accordingly, we have Karbi Anglong Kala has surveyed it and communicated to the, my lord, NHIDCL as well as so that a 3A notification can be published. Then again meeting was held in the presence of the chairmanship of the chief secretary. Then my lord NHIDCL raised a question and wrote a point that whether land is required to be taken as a forest land or the my lord private land. And the amount of about 3 crores has been deposited in the Campa fund as a forest land. Now out of the total amount of compensation determined was 12.98 lakhs, and out of my lord 3.5 lakhs, only for that purposes, my lord, has already been deposited to the my lord Campa fund. What will happen to that? On that, my lord, whole matter is my lord pending, my lord, now. Only for that purpose only pending. And it is, we have filed the affidavit at page 337. It is there.
Pending for that.
Lordship,
Only for that, my lord.
Lordship, we are not
And
dealing,
because
Lordship,
they could not
we
be
want
completed.
construction, Lordship. To that effect also, we have filed.
First of all, you are not raising, if you don't want the land, don't take it. You want the land or not?
Yes, we want.
Why you are not issuing the 3A notification or the 3D notification? Because you cannot complete the road without that.
Lordship, because Lordship in the land, Lordship, some persons are claiming that they are having the patta, Lordship. That is why, Lordship.
Patta, no patta, whatever may be.
That will be decided by the revenue department,
Because
Lordship.
if I'm not wrong, when I took up this matter
Yes, my
earlier,
lord. My lord.
it was categorically mentioned that this forest was de-reserved
My lord.
in 1965.
My lord.
Isn't it?
Yes, yes, my lord. Yes, my lord.
1965, it was de-reserved.
My lord.
You don't want it, it's okay.
Lordship,
Then
no.
close it, don't go ahead.
Lordship, we want,
No,
Lordship.
you don't need to.
We want, Lordship. That is why, Lordship, I filed one application, Lordship.
We do one thing, we close it, do anything. Very well. Let them not do anything.
No, Lordship. Lordship, Karbi Anglong authority is to place the, Lordship, we will deposit, Lordship. That amount already decided, Lordship.
And we have annexed it, my lord. We have annexed it, my lord.
Amount.
If you are delaying it out there, you cannot.
PS 330, my lord. We have, my lord.
They have done
We
it.
have already.
First of all, I have serious doubts as to how the revenue department of government of Assam will have a say.
My lord.
Because it is absolutely comes within the 6th schedule area. One. Secondly, you have anything as regards the forest or not? That is the another aspect of the matter. But the fact that they are in possession of the land, they are at least entitled to the easementary rights.
Yes, yes, Lordship.
Isn't it, Lordship? Even if you go by the judgments, whereby the ownership is there and these these persons are tenants, then also it is given by the Supreme Court as far back as in 1980 onwards that 75% will go to the tenants and 25% to the landowners.
What is the person interested in the
Person
matter?
interested.
That is the word.
That is-
Lordship has already earlier observed, my lord. That is the word, person interested, not the potta holder like that, my lord.
You finalize and give us an update
Lordship,
on the next date.
Lordship.
We have it in the month of September, October,
My lord.
first week.
October, my lord, it will be, if the road is equal to be completed, my lord,
So in the
October,
meantime,
November.
let them, there's no
My lord.
stay out here.
Hmm.
There's
Nothing,
no
my lord.
stay out here.
My lord,
Let them take the process of
My lord.
3A and 3D
my lord,
on before that date.
my lord,
Let them take whatever steps
my lord.
for them to give an update. In the meantime, they can initiate 3A, 3C and
My lord.
3D. And thereupon give an update on the
My
next day.
Lordship.
I've heard Mr. J. Sutia, the learned senior counsel, senior counsel, who is also the standing counsel of the KAAC, who submits that the Karbi Anglong Autonomous Council had already prepared the minutes. I have already prepared the the compensation payable and forwarded to the NHIDCL. Mr. R.K. Talukdar, the learned standing counsel of the NHIDCL, on the other hand, submits that the matter is now presently pending with the Revenue Department of the Government of Assam. This court finds it very pertinent to take note of paragraph 3 of the 6th schedule to the Constitution of India vests the rights of the land upon the Karbi Anglong Autonomous Council And this court finds it under such circumstances, taking into account the submission of Mr. R.K. Talukdar, the Learned Standing Counsel of the NHIDCL, the portion of the land would be required for acquisition for the purpose of completion of the road, which remains incomplete to the extent of 1.5 kilometers on account of the acquisition process being not over, lists this matter on 5th of October 2026 for an update. In the meantime, the central government as well as the National Highway Authority, the NHIDCL, with the help of the competent authority for land acquisition, shall take appropriate steps and provide the update.
Lordship, conducting counsel is in court 13, so matter may be kindly taken up after some time.
My lord,
Yes, what is your instruction?
My lord, I have not received the records, my lord. The lordship wanted to peruse the records, my lord, as per last order.
No, the last order says that you are to provide instruction as to whether 5,17,000
That is,
is only for land or jirat, and also obtain instruction as regards the apprehension of the petitioner of demolishing of his dwelling house.
that instruction is not available. That instruction is not available, my lord.
The instruction which were sought for by this court on 8/5/2025 not been placed by the Water Resource Department of the Government of Assam,
This is Dima Hassan, my lord.
by the NC Hills. The Standing Council of the NC Hills. So taking into account the above, list this matter again on 12th of August 2026, on which date NC Hills shall, what is this? NC Hills Autonomous Council?
Yes, my lord.
Shall without fail provide the instruction as sought for by the order dated 8/9/2025. Full stop. The interim order passed earlier shall continue till the next day.
Obliged.
Bless. Yes, Mr. Mukherjee.
Lordship, the petitioners are the legal heirs of a person who had purchased the plot of land by registered sale deed, and her name was also there in the Jamabandi, Your Lordship.
Then
Thereafter, annexure 4 at page 25 may be perused. While they were possessing the land,
relation of the mutation and vacation from the encroached land. With regard to the, I am directed to cancel the mutation caused erroneously on a plot of land 5 bighas covered by so and so. The name of so and so. On of so and vacate the land. Okay, then
we approached the concerned authority to get a copy of the order which is mentioned there, Your Lordship. That was
21/7/2022.
11/7/22, Your Lordship. There is a mention.
11/7.
In pursuance to that order, Your Lordship, they are saying that the mutation has been cancelled. They are saying that in pursuance to 11/7.
Then
we prayed for a copy, we were not furnished. Then they tried to evict us, Your Lordship, because saying that our mutation of predecessor is cancelled, Your Lordship. Thereafter, we approached this court. They have filed their affidavit stating that there had been some proceeding in page 34, Your Lordship. They have annexed the order sheet type.
11/7 order is here.
No,
Okay, this is different order. Where's the 11-7 order?
that is not brought on record, Your Lordship.
Why?
So that is not before it's go today.
You have filed an additional affidavit, you have filed everything.
Lordship.
Why you have not produced the 11-7? What is this?
Lordship, as per the additional affidavit, Your Lordship, Lordship sees that by the order date 21/7/25, this honorable court was pleased to direct the respondent authorities to clarify whether a notice was issued to the mother of the petitioner before deletion of her name from the land record. Thereafter, Lordship, at para 4, Your Lordship, they have stated that by letter dated so and so, a notice was served to the petitioner's mother prior to the cancellation of the mutation and vacation from the encroachment. Subsequently, it is also noteworthy to mention that the service of notice was also recorded in the order sheet dated 14/2/2023 provided by the Land and Revenue Department. Now, in that order sheet, Lordship, it is reflected that both parties attended the court notices, duly heard the parties, and thereafter the circle officer submitted a report dated 19 January 2022, along with the copies of the Chitta and Jamaband and original petition of so and so.
And that order sheet, Your Lordship, if I may point out, that is of 2022. The mother expired in 2016, Your Lordship. This order sheet that they have placed, it shows Nizor Boro versus Sakina Beva. We are not a party to that order, Your Lordship. And the mother of the petitioners passed away in 2016, Your Lordship. This is a proceeding of 2022, Your Lordship.
Why haven't you filed a reply?
Lordship, to the affidavit, additional affidavit. We can file a reply.
You have not filed your reply to say that all these things that he might expired on so and.
We have not filed.
Then
the death, the fact of death was in the affidavit, in the main petition itself, Your Lordship.
oh, here, the death certificate is here,
Annexed, Your Lordship,
page 23.
page 23.
And you have served it on the mother. What do you say about Annexure 3, page 23 of the writ petition? Proceedings initiated in 2020. And you served upon some spirit? Dead person?
Lordship, that is true, Lordship. But if Lordship comes to page 36, Your Lordship, of the additional the first paragraph, Your Lordship, the third line. The Jamabandi records of the surveyed village so and so have been further so and so Lordship. The third line, the records also read land measuring 1 bigha 4 kata 6 less of dark number so and so being mutated as per order of Anglo BB and Jalhak Musafid by unregistered deed, Your Lordship. We have stated that here, Lordship.
Where?
36, Your Lordship, third line, it starts. Page 36. The Jamabandi records of the surveyed village Bilaspuras being further found to read that as per the order dated 31/7 issued by the circle officer, land measuring so and so of Dag number 53 was field mutated in the name of Sukra Singh Gayari, son of so and so, substituting that of
On the basis of an unregistered deed?
Number 1, annexure 1 is the registered sale deed, Your Lordship, to the petition, by way of which my mother had purchased the property.
Where?
Annexure 1, it starts at page, the typed copy starts at page 12 and the photocopy at page 15. It was purchased from one Gendrai Boro, and his name is
from whom?
Gendrai Boro.
Isn't this land which falls within the tribal area?
Lordship, it is much back, Your Lordship. It is prior to the sale deed is of the year 75, Your Lordship.
75, it was not a tribal area?
It was BTC was not formed yet.
Forget about the BTC, it was always a tribal area.
Lordship.
Tribal belt?
Sidli tribal belt, Lordship. Sidli tribal belt.
There was a restriction.
How did you, without the permission under 165?
Whether the restriction was at that point.
Not restriction. Restriction was there from 165 was there. Chapter 10 was there. Wasn't chapter 10 there?
Lordship, I'll have to take instruction whether any permission was sought or not. Because there is a registered sale deed rightly or
possible. That is why they passed the order saying about 165. How do you say that it's a 75 day?
Lordship, from the Jamabandi also, Your Lordship, at page 22, the remarks column.
Yes. As per the order dated 22/1/1990, name of Gondhai Boro has been mutated in place of Birendra Bosumatari on the strength of the registered sale deed. As per the order, the say name of so-and-so has been mutated in place of Gondhai Boro, and as per order, namely, say has been mutated in place of Angu Baby at the sale deed. Who is the vendor?
Gondhai Boro, Your Lordship.
So Gondhai Boro's name entered only in 1990.
Lordship, the original of the sale deed I can produce for inspection, Your Lordship. It is 1975, which is annexed
What?
as Annexure 1, Your Lordship. This is the mutation order of 1990. Your Lordship.
Heard Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner, and Mr. N.R. Sharma, who appears on behalf of the BTC. The present petition has been filed by the petitioner challenging the order dated 21/7/2022, whereby the mutation made in favor of one Angu Bewa, author of Rasan Ali, and Muhammad Seher Ali, son of Nazir Ali, were cancelled, and they were asked to vacate the encroachment at the earliest. Case of the petitioner. The mother of the petitioner. Mother of the petitioner, na?
Mother,
Huh?
Mother, Lordship. Ango
Mother of the petitioner had purchased the said land by the registered deed of sale bearing deed number. Deed number? What is the deed number?
Deed number
No deed.
7721/7751.
Where?
Para 2 of my
No, original.
Lordship. It is not legible, Your Lordship.
What?
I have mentioned it in my para 2 of my
No,
petition.
no. There is no deed number. And you have enclosed a document which is not legible.
Lordship, I can produce the original.
This is a certified copy. This is not even the original. And the
Certified.
certified copy, you don't have a better copy. Basis of a registered sale deed, purported registered sale deed, dated 3/6/1975. This court have taken note of the affidavit filed by the respondent number 4, wherein it is mentioned that The or impugn order was passed on the basis of the BTC Secretary Order Number BTC/LR.380/2022/15 dated 11/7/2022. And the power has been exercised, which is traced to sections 165 bracket 1, 165 bracket 2, and 1 traced to subsections 1, 2, and 3 of section 165 of the Assam Land and Revenue Regulation 1886. Considering the above, this court directs the respondent number 4 to produce the copy of the order dated 11/7/2022, reference of which have been made in the affidavit in opposition filed by the respondent number 4. In addition to that, the respondents shall also place on record as to when the particular area wherein the land in question is situated have been declared as a tribal belt. To come within the ambit of Chapter 10 of the Assam Land and Revenue Regulation 1886. The petitioner is further, the counsel for the petitioner is further directed to place on record a copy of the original deed of sale, and further as to whether any permission was taken prior to the execution of the deed of sale. List this matter again on 21st of August 2026. The additional pleadings be brought on record by both the petitioner as well as the respondent on or before 19th of August 2026.
Lordship, about the tribal belt, Your Lordship, it says that it was notified on 5th December 1947.
You file your bring on record that document. What is this?
In this case, my lord, in 2003, Lordship, with due permission and as per plan of the, my lord, issued by the Kharopite municipal, Kharopite, at that moment it was town committee, Lordship.
Demolish the petitioner
petition
three-story
constructed-
building by municipality holding number so and so structured in his land under Dolgao Revenue Circle in the district of so and so. Why?
My lord, the municipal board, my lord, municipal board, my lord, came to demolish the home, Lordship.
Why?
Saying that the land, building is, my lord, in government land, Lordship.
Huh?
Saying that this is in government land, Lordship.
Who wants to demolish?
My lord, municipal board, Lordship.
You?
My lord, after interim order, Lordship, application for vacating interim order was also filed, Lordship.
It's okay. You are appearing for Kharupetia Municipal Board.
Yes, Lord.
You want to demolish.
Lordship, I kindly peruse next the 4 of my interlocutory application, Lordship. That is in page number 50, page number 20, Lord.
Sir?
4 of my interlocutory application. Page
The
number
what is
80,
the interim order passed?
page number 18. Lordship.
Next,
There is a
no action for demolition be carried out in respect to the as described in paragraph 3 of the petition, which is over a plot of land, dark number, and periodic patta number emerged. How, if it is a periodic patta number so and so, obviously, then it
Lordship,
cannot be government land.
demolition is to be carried out.
Where is Annexure 4 page?
Annexure 3, page 18.
1/8.
My eye.
Yes.
There is a report given by the circle officer, Lordship. And based on that, Lordship, the whole exercise was carried out.
With reference to, I would like to inform you that on the basis of a document dated so and so from the office of the Kharbe and the subsequent notice issued on so and so, the boundaries of the government dark number so and town have been demarcated. And as per the report of the Lokmandal during the process of demarcation in a part of the land, total land, 3 kathas so and so, RCC building was found to be standing on it. It is seen that the said building has been used as a business and it is learned that the owner of the is so and so. And for your information, then
Yes, Lordship. So, Lordship, based on this particular report, Lordship, we carried out, there was this scheme, Lordship, the Mukhyamantri Pokipot Yojana, Lordship. And
Mukhyamantri,
Pokipot,
put your mic properly. Yes. Mukhyamantri?
Pokipot Yojana,
Ah,
Lordship.
then
So, in that scheme, Lordship,
Mukhyamantri Pokipot Yojana, does municipal has anything to do?
yes, Lordship. The whole exercise, the whole exercise was carried out by the municipal board only, Lordship. And later on, Lordship, during the period of this litigation also, Lordship, a fresh demarcation was also initiated, Lordship. And if your Lordship kindly peruse the order dated 27/8/2025, Lordship.
By this court?
Yes, Lordship. In that order, Lordship, it was observed that the circle officer is carrying out another demarcation process and the report is
Seven.
still awaiting, Lordship.
27,
27/8/2025.
yeah. The Bourbon so and so. Covered by dark number EI is under process. He submits that such within 6 weeks. Now, what has happened then?
Then the particular report is still awaiting, Lordship. The same has not been brought on record.
Now tell me,
Sure.
you have been informed. HEE, the document by the circle officer.
Yes, Lordship.
But tag number 1220
Yes.
belongs to the state.
Yes, Lord.
Okay. Now, why the state has not initiated proceedings under Rule 18? What? And why are you there? You have nothing to do with this.
The
You grant the permission for construction of the land, of the building.
Lordship, we have filed an additional affidavit, Lordship.
Understood. My question is, did you grant the permission for construction of the building or not?
Yes, no, Lordship. Building has been constructed by them, Lordship. We are constructing road, Lordship. We are constructing road, Lordship.
You are Kharupetia Municipal.
Yes,
Board.
Lordship.
Did he construct the building in Kharupetia Municipal Board with your permission or not?
Lordship, that is in 1219. Tag number 1219, they have got all the permissions and everything, Lordship.
They
But
have construction of the building,
yes, Lord.
but it is in respect to tag number
1219. So,
But in tag number 1220, they have constructed.
yes, Lord. Yes, Lord.
Now, it is for the circle officer to take an action. Who are you?
No, Lordship.
If it is a government land,
Yes, Lord.
somebody has constructed over the government land and you have not been provided the land
Yes.
by the government. You have the authority to exercise action for demolition.
Lordship, what had happened,
They
Lordship?
may very well do it if they want.
For that clarification, Lordship, we have sought for instruction from the circle officer, Lordship, and based on that application, Lordship, they have given us this report that 1220 belongs to government land, Lordship.
Understood.
So,
Let us assume that it is government land. Now,
if
are you
the
going
road
to
is to be-
interfere out there as regards the construction when they don't have any objection? They have not, they can initiate proceedings under Rule 18. They have not. Who are you?
So,
That land does not belong to you. They have constructed. They have constructed on a permission. Permission was granted by you. They may have done it not in 1219, but they have done it in 1220. For the circle officer, he requires to construct. It has been asked to demarcate. The circle officer has not demarcated anything. Although this happened in 2025, this was the direction so passed to the. My question is, who are you?
I'm the authority
You are not
to.
the owner of the land.
No, Lord.
Then
I'm the authority to construct the land, Lord.
you have authorized them. You have no,
Construct
you
the-
have granted the permission to construct it.
There is. There in page. Lordship, may kindly
What?
give me some time.
Where is your term? Where is your communication for the
Yes, Lord.
means, demolition?
No communication, Lordship.
What?
Suddenly came, Lordship. I have stated in paragraph 8.
What? No. We interfere with this.
We have, I have found that report
madam.
from 30th October, Malak. 30th October, Malak, that because of Malak survey team of the joint
Madam,
director.
the land belongs to the state.
Yes, Malak, government land, Malak.
You say
Yes, Malak,
he has constructed with a permission
Malak,
from them.
Malak.
Who are they to demolish?
They have to produce
Who have the power under Rule 18 to demolish?
Malak,
There is a, if there is a land which has been constructed over the government land,
government land.
then who is the Kharupete Municipal Board to construct? Where's your permission, Mr.
Lordship, Lordship, may kindly
Your
give me one.
permission, it has at least 46 laws,
40?
46.
46.
Laws. This is
46.
plain lordship, and the permission at
Permission for construction of a new building. Have granted on 1219, and you say that it is, the construction is on 1219.
Yes, Lord.
You say by that.
Lord.
Now, they want to demolish because it is in government land.
Lordship, we are
Boundary
clear.
wall is in the government land. Boundary wall, the petitioner is on the government land.
Let's see page 18 again. That page you are referring to, Mr. Council? Because I-
46 law.
Yeah,
46.
page 18 of the IA.
Page 18 of the Lordship.
RCC building was found to be standing on it, not boundary wall.
My lord, I
Please
have,
read page 18.
we found the, my lord, parawise comment here, my lord. The petitioner's boundary wall was constructed over government land reserved for drain. The petitioner constructed the boundary wall
No,
over
no,
government land which was reserved for
Now,
drain. my lord.
now kindly come to the IA, which has been filed. They have been written by the circle officer to the chairman of Kharupatia. See,
Yes, my lord.
the translator
এতিয়া বৰষুণ হয়। মই যাই ইমান দূৰ।
পকী ঘৰ অৱস্থাত হৈ থকা দেখা যায়। So there is an RCC building,
Yes, building is
dark
there.
number 1220.
Yes, my lord. But boundary wall has been constructed, my lord, over the plot government land which has been just reserved for drain, my lord.
So therefore, they have not constructed the house over there.
House, yes, here, my lord, from the,
But this communication is different. Kindly see page 19 of the IA.
yes, my lord, I have seen, my lord. 220. 1225.
So if any action is to be taken, it is to be by you.
My lord.
Why are they taking action?
Lord, may I pray for 1 week time so that I can take, my lord, the clear picture will be, my lord, come. Otherwise, how they have come, my lord? He has not come with that particular, my lord, where from he got the right to, my lord, demolish the land. He must have some
There's no
order
business.
or something, my lord.
Kharupatia municipal board has no business.
Lordship, may kindly give me some time, Lordship. We'll take up the instructions, Lordship, in that regard, Lordship.
Instructions. You answer
some-
to my query to the effect.
Yes.
Are you the sole counsel or anybody else?
Lordship, Mr. A. Sharma is the conducting counsel, Lordship. I am appearing on his behalf. Mr. A. Sharma.
E. Sharma?
A. Sharma.
Then,
I am appearing on his behalf.
if your basis is page 17 or page 18, your IA, then you have no business. Heard Mr. M.H. Ahmed, the learned counsel appearing on behalf of the petitioner.
1220.
The so-and-so, Miss so-and-so, Ms. Yudas appears, the additional senior government advocate appears on behalf of the respondent numbers 1 and respondent number 2, 3, 4. PR Monte appears on behalf of the respondent number 1 and Mr. So-and-so appears for respondent number 5 and 6. Petitioner has approached this court challenging the action on the part of the respondent number 5 and 6 to initiate steps for demolition of the petitioner's RCC building. Mr. Ahmed, the learning counsel appearing on behalf of the petitioner submits that the petitioner is the owner of a plot of land at building 1 Katha 10 Church, covered by tag number 1219, included in periodic patta number 478, situated at Kharupotia town, Moza Kharupotia under Dalgaon Revenue Circle. Mr. Ahmed, the learned counsel for the petitioner, further drew the attention of this court to the permission which was granted to the petitioner on 2nd of January 2003 for construction of a 4-storied building The approved plan have also been enclosed to the writ petition. It is the specific case of the petitioner that the said permission that the Kharupetia Town Committee had unilaterally decided to demolish the building. This court also takes note of the submission made by the learned counsel appearing on behalf of the respondent number 5 and 6, who submits that such steps have been taken on the basis of a communication issued by the circle officer, Dalgaon Revenue Circle, whereby was informed to the chairman of Kharupetia Municipal Board that the petitioner had constructed an RCC building over the government DAGs numbers 1220, 1225, 1225. This court finds it relevant to observe that the power which is reserved upon the Kharupetia Municipal Board is only to take action if there is a violation to the permission so granted. The respondent in the district administration of Dalgaon, in the opinion of this court, they have not taken any action for recovery of possession or evicting the petitioner in terms with Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Under such circumstances, the question arises as to whether the Kharupetia Municipal Board would have unilaterally, without issuance of any notice to the petitioner, take such steps of the petitioner's property, petitioner's RCC building. Considering the above, this court prima facie is the opinion that such action on the part of the Kharupetia Municipal Board, that is the respondent number 5 and 6, is not in consonance with the settled principles of law Accordingly, this court is not inclined to vacate the interim order which was passed by this court
On 3/2/2023.
on 3/2/2023. The interim order which was passed on 3/2/2023 in the instant writ petition stands extended until further orders. The respondent number 5 and 6 is granted an opportunity to explain as to how such an unilateral course of action was permissible, that too when the land admittedly did not belong to the respondent number 5 and 6, and the allegation is that the land is a government land. This matter again on 4th of November 2026. In view of the order passed in the main writ petition, the IUH stands closed. However, the registry is right to tag the records of the present interlocutory application, as the said records have a vital bearing on the disposal of the writ petition.
Lordship, only one prayer, Lordship. Can it be in the month of September, Lordship?
Okay, December, more weather must be
September, Lordship.
Where will you go?
Like that.
Go September. You want, I don't understand why you are after that.
Some personal interest is there, Lordship, that is the.
Okay, we have it in the month of October, 7th of October.
Yeah.
Lordship, item 30 and 31 are similar matter, Lordship.
What is this? What are you challenging?
Lordship, here what happened, we have received a notice from the controlling authority of labor code. And then we filed an objection. We raised some preliminary objection and requested them. The ground of jurisdictional error, Lordship.
Your Lordship, he has worked there from 1995. I am for the respondent number 2. Kindly come to page number.
Lordship, page 15 of item 30, Lordship.
Why are you here? Why you are not approaching the under 7.7?
Lordship, here what happened, Lordship, we are challenging, we filed an objection, raising preliminary objection and submitted before the authority that if the authority is not satisfied, then necessary copy may be supplied to us so we can file our reply. That was not done. In spite of that, Lordship, final order has been passed.
Where is your petition?
Petition is page 15, item WPC 494.
But what is the preliminary objection you have raised?
Page 15.
Yes, what is it? So and so is a subordinate officer and clearly beyond the purview of Industrial Disputes Act. Therefore, as the department cannot be termed as an industrial establishment, and as such, the issue sought to be raised by the wagers cannot be termed as an industrial dispute. The following case laws supplement the year, so and so. Can be, in view of the above, you are requested to posture. In case you are not in agreement with the department, you are provided to provide so and submitted by the applicant and is able to submit further written submissions to you. Then order was passed.
Order was passed without considering our this objection.
Where?
Page 16.
Where do they say that it was that it will fall?
Lordship, page 16 is the final order. It continue up to page 20.
Where they have decided?
No, Lordship, they have not decided. They have not touched our preliminary objection also.
So your basic thing is whether it falls or not.
Yes, Lordship. And if that authority said that we are falls under the industrial, if the authority come to a conclusion that we are falls under the Industrial Dispute Act, then Lordship, we requested them to provide necessary documents so we can file our written statement. That has not been considered. Lordship, I want that matter may be remitted back to the authority.
So that means you agree that you are in industrial dispute.
No, Lordship, if the authority comes to a conclusion, because nothing has been decided.
Authority has come to a conclusion means authority have not decided that.
Yes, authority has not decided that, Lordship.
Your Lordship, I'm for the respondent number 2. My contention is that
Who are you?
I'm
He's
Tapan,
a workman.
workman. I'm the workman.
Okay.
The
You
authority-
were working where?
I am working under the Deputy Commissioner, Custom Division, Karimganj. From
What
1995.
division?
Custom Division,
Custom Division, Karimganj.
Karimganj. I've
Okay.
worked there from 1995 till 2023. I have working there continuously
As?
as a fresh forest come water carrier, as a water carrier, Your Lordship. And when I retired, I just want my gratuity, Your Lordship, because I've worked there continuously and nothing else. And when I approached the industrial tribunal, they have give award in my favor. If you come to page number 24, Your Lordship, the fact of the order, Annex 1. I think, Annex
What has happened to the recent judgment of the Supreme Court was hearing on the question of industry, na?
That is pending, Lordship, still pending. That Bangalore Water Supply Board has been, that Bangalore Water Board has
That
been,
was taken up, na?
Lordship. No final order has been come out.
So it is this issue.
Lordship.
Let us first decide.
Lordship.
We can decide as to whether you will come within it or not.
Lordship.
You come, then we can very well grant.
Lordship, our limited period is that somebody has to decide that our department falls under this. And Lordship, alternatively, we prayed that if authority decide that.
Now, when you are raising that jurisdictional issue, let us first decide
Lordship,
to whether the
Department of CGST falls under
the department of the GST department. But why do you say it has to be an industrial dispute?
Because Lordship, it was filed by the workman.
For the payment of gratuity.
Lordship.
Does it say it's to be payable by the industry?
Yes, Lordship.
Where? Don't think industry has anything out here. An act to provide for a scheme for payment of gratuity to employees engaged in factories, mines, oil fields, plantation, ports, railway companies, shops or other establishment, and for matters connected therewith or incidental. Then
No, whether
to come within the ambit of any of it. It shall apply to factory, mine, oil field, plantation, port, and railway company. Every shop or establishment within the meaning of any law for the time being in force in to shop and establishment in a state in which 10 or more persons are employed or employed on the day of proceeding. Such other establishment or class of establishment in which 10 or more employees are employed or were employed on any day of the preceding. A shop or establishment to which this act has become applicable shall continue to be governed by this act, notwithstanding the number of employees having been here. So here the question does not arise. Appropriate government means so and so. Why are you into this industry business?
Because
The industry has no business with this.
no, Lordship, but the notice has been issued as page 10. Page 10.
Yes.
It was issued by the Office of the Assistant Commissioner, Labor Commissioner, Central, Kendriya, Southern, Silchar, Lordship.
No, understood. But why are you saying on the question of industry?
Because
the Act, Payment of Gratuity Act has no relation with an industry.
But Lordship, the definition does
Do you
not.
have a copy of the document on the Act or not?
The copy,
You have it or not?
I don't. To be
No, how are you arguing, Mr. Kyle? This is not, it's very unfortunate. You don't have a copy of the book. You have raised that you are not an industry. Industry has no business out there with the Payment of Gratuity Act.
Lordship, in the
You have raised, so we dismiss your petition on this ground.
and Lordship,
Raise issues which have no relevance.
no, Lordship, in the
Yes, we
bottom of
dismiss
the
it.
in bottom of the our in case you are not agreement with the department's view, you are requested to provide documents, data, information submitted by the applicant so that the department is able to submit further written submission to your office. That has not been considered, Lordship. And this issue has not been touched by the authority who has passed the order. He has not.
No, you have raised an issue that it is not an industry.
No, Lordship. Yes, Lord.
That it could not have been a big issue.
That then even if under the circumstances, we requested the department to provide the document so we can file our return.
So therefore you give up all these things.
Lordship, in view of the act, Lordship, in view of the provision of the act, we are.
So you mean to say that you agree that it comes within it?
Yes, Lordship.
You have instructions for that?
Yes,
To
Lordship.
agree
No,
that you are, huh?
I have no instruction. Because
Then how are you making that submission? The moment I do this will have far-reaching consequences in all other departments.
But
You
Lordship,
can't make that submission like this. Make this submission with a sense of responsibility.
alternatively, we put it,
Moment I say, you on one hand have approached this court on the question of jurisdictional error.
that
That it is not an industry. That obviously could not have been the ground. Industry or no industry has no relation. It has to be as to whether the Payment of Gratuity Act applies.
yes, that is.
That's it. Now, Payment of Gratuity Act applies only to these set of things. It has to be an establishment. It has been defined what is an establishment. It has been defined what is a mine, what is a railway company. All these things have been defined. So the moment you are saying that you are going to supply, you have to submit all these things. That means what?
No, Lordship, in the objection we have in the last paragraph, we stated clearly that if the authority.
Understood. So therefore, the question is, you give up your claim that come within the Payment of Gratuity Act or not?
Lordship, our submission before the authority was that in case the authority decides that we are not industry or we falls in.
That is why, Mr. Kyle, I'm saying industry has no relevance.
No, that is correct, Lordship.
The relevance is as to whether the GST department will come within the ambit of the Payment of Gratuity Act. That is the issue.
Yes, Lordship.
And for that, industry has no relevance. It is not, the Industrial Disputes Act doesn't come into picture. It has to be whether these are the questions, so these are the, whether you fall within the ambit of these. Factory, mine, oil field, plantation, port, and railway company. Or an establishment. Establishment has been defined. Establishment is every shop or establishment within the meaning of any law for the time being in force in relation to shop and establishment in a state. You come within the ambit of the Assam state some shops and establishment act?
Probably not, Lord. The GST
Well-
department is a department for collecting tax and others, Lord. It is not fall under
Because the moment I hold it to that effect and decide the jurisdiction issue, it will impact everybody.
everyone.
And it will be a case of embarrassment unless you have instructions to that.
Let's say then take next week, Lord. I'll have instruction from the Chief Commissioner, Lord.
Or Mr. S.C. Kyle, the learned senior counsel, assisted by Mr. K. We have,
31.
Huh?
Along with that, item number
use
31.
that mic. You have a mic.
Item number 31, my lord.
Ah.
As the APR is response number 2.
He appears for
Same
response.
case.
He's in item number 30.
30, Your Lordship.
Okay. Mr. So-and-so, the learned counsel who appears, senior counsel is on behalf of the petitioner. So appears on behalf of the respondent number 2 in probably 2024. And Mr. So-and-so appears on behalf of the respondent number 2 in WBC number 4144/2024. It is the specific submission on behalf of the learned senior counsel appearing on behalf of the petitioner that a preliminary objection was taken before the controlling authority that the petitioner is not an industry coming within the ambit of Section 2S of Industrial Disputes Act 1947 and therefore was not liable for payment of any gratuity in terms with the Payment of Gratuity Act 1972. The learned counsel further, senior counsel further submitted that it is also the case of the petitioner that in the communication we are raising the preliminary objection, it was also mentioned to the controlling authority that if a decision in that regard was taken, the petitioner should be granted an opportunity to submit their reply on the merits of the claim. This court have duly perused the preliminary objection which was filed in both the writ proceedings, and from a perusal of the said preliminary objection so raised by the petitioner, it is the opinion of this court that the said preliminary objection to raise said preliminary objection is irrelevant as regards the applicability of the Payment of Gratuity Act 1972 to the petitioner. This court opines so on the basis of a perusal of the Payment of Gratuity Act 1972, wherein in section 1(3) of the said act, it is categorically mentioned as to where the provisions of the Act, Payment of Gratuity Act 1972 would be applicable. Question of an establishment being an industry or not within the meaning of Section 2S of the Industrial Disputes Act 1947. Therefore, in the opinion of this court, has no relevance. Be that as it may, a question definitely arises as to whether the Payment of Gratuity Act 1972 can be made applicable insofar as the GST department, which is the department of the government of Assam, created under the provisions of the Central Goods and Service Tax Act 2017. Mr. S.C. Kyle, the learned senior counsel submits that he has no instructions in this regard and he would make necessary submission on the next date. List this matter on 28/2026, on which date this very aspect of the matter would be heard and so at 2 p.m.
But see, in spite of state of Assam, it's in government of India laws.
Huh?
The Department of Government of India laws.
The government of
Much of it.
There's an interim order.
Another interim order did not continue in my case, 31, because initially it was given the interim order. But in the on order dated, there is a
There is no interim order.
No.
interim order.
May I please, Lordship, in this matter, the respondents filed a affidavit I have received today morning, Lordship. I need some time to go through. Can it be taken up after a week or Lordship, subject to Lordship's convenience?
I'll reply.
I just need to take instructions, Lordship, on this matter. You'll not file any reply.
The case about?
Lordship, for delay condonation in filing a revised return, we had made an application under Section 119 of the Income Tax Act, which was rejected by them, saying that the revised return cannot be filed. There was some mistake of law. Under presumptive taxes, we were supposed to file our return, but we have filed a regular return without calculating our income under the presumptive taxation system, Lordship. So we seek a revision within 3 years of our original filing return.
Let us see the impugn order.
Impugn order, Lordship, will find Annexure 7 starting at page 89, Lordship. Condonation of delay in filing Form 10 under Section 119 2B, rejection order. Here they say that we do not fulfill the criteria laid down in the board circular, but board circular is very clear that any condonation has to be within the period of 6 years.
So this is done in terms with next page 91.
Page 91, Lordship. But that's
Serial number 3.
Lordship, that is clear. So
Then?
we had filed within the time period, Lordship. It was much before the 6 years period.
You filed when?
My application was filed on 24/5/22.
You filed your return on 21/7/2017.
Lordship.
Didn't it?
Lordship. Then
But,
revised return.
27/7.
Revised return can be filed within March of the following year.
The next one you filed it on 19/7/2018.
Yes, Lordship.
Okay.
Yes.
So
that was the original return.
Your return was to be filed. It says 3. No condonation application for claim of refund loss shall be entertained beyond 6 years from the end of the assessment year.
Lordship.
So
My-
assessment year 2017
18.
ended on 31st of March 2017.
No.
Yes.
Assessment year 17-18.
No, 2000 year, whatever may be, financial year.
Financial year is 16-17.
16-17.
Yes.
So that financial year 16-17 assessment year is 17-18.
18, Lordship.
So 17-18, the period of filing is on 31st of end of the financial, end of the assessment year would be for 16, assessment year 17-18.
So it ends on 31st of March 2018.
Assessment year 2017-18
Yes.
ends on
31st March 2018.
this was 2018. And assessment year, the other one was
18-19. Assessment year is 18-19.
is on 31/3/2019.
Yes, Lordship.
And therefore, and when you file this application for return,
On page 35, annexure 2, on 16 October 2020, for both the assessment years. Seeking revision.
10/10/2020.
Lordship. Yes.
In 2020. Both were filed.
For both the years, Lordship.
Were filed.
Yes, Lordship. Lordship will find the subject application for condonation of delay in filing of revised returns for claiming of refund for assessment year 17-18 and 18-19 with reference to Circular 9 of 2015. Then we send a reminder on annexure page 36. We send a reminder on 24 May 22. Then a third reminder was page 37, which was 24 March 23. Then they, for the first time, responded on 35/23, seeking for additional documents in support of our application, which the Lordship will find on page 38.
Where will we find, Mr. Todi, Dr. Todi, where will we find that the assessment year period ends on 31/3/2018? It will be there in the Income Tax Act.
Lordship.
Year means the period of 12 months commencing on the first date of every year. So 17-18 will be from 1st of April 2017. 1/3/2018.
No.
Yes.
For 17-18 financial year, assessment year will be 1st April 2018 to 31st March 2019.
No, 17-18 will be from 1st of April 2017.
No, 18.
No.
Your Lordship is speaking of the assessment year.
Assessment year 2017-18
Yes.
will start from 1st of April 2017
17.
to end on 31st of March 2018.
18, yes.
Yes, that is what I am saying.
Lordship.
Because if you see the definition of 2(9), assessment year means the period of 12 months commencing on the first date of every year. Means of that year, of
that year.
2017.
Yes.
It starts on so-and-so and ends on so-and-so.
Yes.
It would be otherwise the financial year would be
16-17.
16-17. Yeah, it will be there. So therefore, it is filed within the period.
Lordship. No, Lordship,
Why 3 has not been taken into consideration? The 6 years.
our stand is that at that 11 point of time, they have failed to file their revised return if they invoke to so. Paragraph 19, page 99, paragraph 9. Your
89.
Lordship.
Page 89. So-and-so returns a condonation of delay of so-and-so and convey you that you are already filed your return on so-and-so. Hence, your application has been rejected by the principal so and so in the light of 119 2B of the Income Tax Act. It considers it desirable or expedient to do so for avoiding genuine hardship. Or the authorized not being the Joint Commissioner to admit an application of claim for an exemption, deduction, refund, or any other if under this act after that period specified by or under this act or for making such application. So now what is the application they filed?
That lordship is annexure page, annexure 3, page 36.
Page?
Page 36, lordship. Application for permitting to file a revised return.
Claiming refund for the assessment year so and so. Now let us see for filing revised return, what is there? Or claim of refund or loss. So claim of refund or loss is 6 years. For revised return, well, what it is? Will be vested with the power of acceptance or rejection of such application claim if the amount of such claim is not more than 10 lakhs for any one assessment year. Will be vested with the power of acceptance, rejection of such application if the amount of exceeds demand but not exceeding 50 for one assessment. The application for amount exceeded shall be considered by the board. No condonation application for claim of refund loss shall be entertained beyond 6 years from the end of the valid
assessment year.
Meet of so and so condonation shall be disposed of within 6 months from the which the application is received. Where there is the application with the monetary limit daily. It shall be ensured that the income declared and on a refund claim is corrected directly.
Paragraph 692, please. Paragraph 692, that instructs. That is the notification.
Paragraph 6 won't be applicable in my case, lordship.
page 98 of our affidavit, paragraph number 9, Your Lordship. That the relevant answer is there.
So you mean to say it was filed within the period of 6 years?
Lordship.
But then also you have the power, as the power is discretionary.
Discretionary.
You have looked into it and found that it was not in
On the format,
not in format. It is the explanation is not, so
not
good,
satisfactory.
not satisfactory. That is the reason
That
why.
is the reason. It is a total discretion of the PCIT.
The reason given, Lordship, in the affidavit is something other than the reason in the impugned order.
Page 98 of our affidavit, Your Lordship.
Are you referring to the 2022 application?
That
Not the 20 application?
20 application, they did not give any notice or did not take up the matter. So we give a reminder, Lordship, in 22 and again in 23. Thereafter, an extra 5 days for the first time in 23, call for additional documents for consideration of our application. Against this Lordship requirement, page 40 annexes 6, we have given all the required documents and explanation. But this reply was not considered in the impugned impugned order. Lordship.
So your claim is some 34,000 and so and so.
Lordship, very minimum amount, because there was
And there is no interest.
no interest, Lordship. Because what had happened, Lordship, there is a presumptive taxation system which have been introduced for in respect of professionals. So under that, on a flat percentage basis, I have to determine my income tax and pay it. That was not known to me. Subsequently, it came to my knowledge. So I filed an application for condonation in filing a revised return.
Section 44 ADA, Lordship, that section.
So here it is, you are not satisfied with the grounds.
Lordship.
The ground is out here, he is saying that, you see, I didn't know about this earlier, but now in 2019-20,
Lordship.
I have assessment year 1920, I have taken the plea of 44 AB. And this I did not take in my assessment year 18 and 18-19, which is 44 AB.
Lordship.
It is otherwise within the period of 6 years. But you did not feel it necessary.
Lordship.
Where is your reason for? Why is it not necessary?
Lordship, page 99 of my affidavit.
You don't stipulate the reason.
Lordship, only reason is that
It was originally filed in so and so. The petitioner attributed the filing of the return to lack of awareness. The petitioner's application was examined in the department. Is the principal ground advance was his subsequent realization of year. He noticed that the valid returns for the register had already been filed by the petitioner. It was further noted the petitioner had not availed the statute of filing revised returns within the period specified under the Act.
Lordship.
What is the period for filing revised return?
That means they if there is any mistake from their side, they ought
What is
to
the period? What is the period for filing the revised?
Within 31st March of the following year, Lordship.
That is the stand on
the period.
45
Thereafter you
return.
require condonation.
Yes, Lordship.
And the condonation is permissible for 6 years.
For 6 years.
Then thereafter, Lordship, the matter was examined in the light of CBDT circular number on detail.
Understood, but you say so. But you don't give the reason why. There's no reason why.
That is a.
You say that you are not satisfied.
And they ought to file in a remediate of filing revised return within the.
Understood.
That is
That is why they are filing the condonation application.
Otherwise, there is no reason why they have
There's
been.
no reason why. Look, I think we can allow this on Thursday, 2 o'clock. But there's no reason why.
Yes, Lordship. That is all my case, Lordship. I
There's
just
no reason
yes.
because they say that you could not, why didn't you? That is why you file your condonation application.
That's all. Because suppose I could have filed within the revised return period, I could have done it like I have done for 1920. Just because for 1718 I could not. So there is a provision under 119. I filed an
A
application.
short reply, then file a short
Yes.
reply.
I will give my satisfaction.
Yes, therefore, that there is no reason. Yes, they had the power, but they say that we are not exercising. When the discretion is granted, the discretion not to exercise also has to be backed by reasons.
True.
The law.
True. Because Lordship has
File an
a
affidavit.
I'm not going to file affidavit only because their affidavit, I need to take a small instruction with the client, Lordship, petitioner.
In the meantime, I also take instruction for clarification of the.
But there's no reason assigned out here.
Lordship.
That is my whole case, Lordship.
That's why
Lordship has gone to the impugned order also.
Okay.
I will try to satisfy on that count.
The record reveals that an affidavit in opposition has been filed by the respondent today. Ms. Dr. A.K. Todi, the learned counsel, appearing on behalf of the submits that he would obtain in certain instructions and if necessary, file a short reply. Next week then?
Next week, Lordship.
This is matter on 27th of August 2026 or 30th of July 2026 at 2 p.m. for final disposal. In the meantime, the petitioner would be at liberty to file any reply. Dr. Gogoi, the learned counsel who appeared, B.N. Gogoi, the learned counsel who shall also as to what was the reason taking into account that from the very perusal of the affidavit, there appears to be no reason as to why the delay was not condoned. May not be out of place to mention that when discretion is conferred, discretion, non-exercise of the discretion also has to be backed with.
Much
Lordship.
obliged.
Sent one letter with your permission. I sent one letter to your office, Your Lordship.
What did you send?
One invitation letter to the Lordship office. Please, take it.
Don't get you.
I had given one letter to you, Lordship, for the invitation card. I have not been, while I went to your chamber that time, we were not with the Lordship, maybe.
Yes, what is this?
31st. Well, this is regarding non-payment of contractor bill.
GMC, GMD,
GMC loss.
GMC,
Yes, loss.
they have not paid.
Loss.
Not a affidavit file.
Affidavit file, now, in the affidavit, they have disputed one aspect, loss.
No document. Status. Oh, this one.
This one, loss.
Taken this matter earlier, I suppose.
Yes,
huh?
yes. Loss was hard this matter.
Naik. What about the instruction pursuant the order dated 15/12?
15?
12/2025. inquired with Mr. P. Naik, the learned standing counsel for the GMC, as to whether there are specific appointment letters thereby appointing supervisors in such as the perusal of a supervision report, which is enclosed to the repetition reveals that the concerned supervisor who gave the reports carry out the supervision in respect to a very vast area. To one contract, it is the entire 6, whereas respect to the other contract, it is ward number 28 and 29, submitted that he would obtain instructions.
Not a pursuant to this,
Because your affidavit which you have filed, particularly at paragraph number 4,
Four,
you say the completion certificate was issued by the then executive engineer of the respective division.
yes, Lord.
Accordingly, the file was processed for further necessary heir to the higher authority. However, it is observed by the superior authorities that no documentary evidence of supervision carried out from the third party monitoring agency was furnished. Further, no documentary photographic evidence regarding status, review, monitoring of the entire so-and-so except so-and-so. Then the superior authority has considered a committee to take the decision on the matter pertaining to release of you wherein the issue of EIA is there. And so the committee has rejected that the work carried out as claimed by the petitioner on the ground that the work is not verifiable on the ground and the photographs do not suggest completion of the work. Then affidavit in reply has been copies of the third party monitoring certificates are annexed I and J. Till date, they have not taken any action against any officer. The whole contention of the answering false certificates given. Then
From the
petitional affidavit has been filed by the petitioner. Letter of acceptance failed to annex the letter of acceptance issued by the respondent.
I mean, pursuant to your lordship's order dated
1512.
1512, lordship.
Mr. Naik, this court has one problem, Mr. Gogoi, I have a problem. Now, if there are certain disputes where they say that you have not carried out the work, you say that you have carried out the work, how can this court look into those? We have understood. I can't pass an order for verification and pay because they have rejected. Therefore, I can only do one thing. I can set aside their rejection or not set aside the rejection. I can very well ask you to go before the civil court wherein you can challenge it. This is the only way out. I can't do anything.
So, kindly see the nature of dispute, first. Nature of dispute, They have disputed, what disputed.
Problem is the dispute.
Dispute,
Dispute which they have raised.
What is what they dispute and the nature of dispute, kindly see. Two things admitted. There is the 38 contract period. For the first 2 years, they have paid. Last year, 33% already paid. There is admitted. 67 remaining yet to be paid. Moreover, there is a completion certificate. The completion certificate is issued on the basis of the record lordship. This is a culmination of the work order. After verification of all this, the completion certificate.
But they have rejected that.
How can they reject?
No, how can they? No, they can reject it, but the rejection, if it is done, it is a question of subject matter of evidence.
Moreover, what they dispute, this is they are. I cannot maintain this photography evidence lordship. They have stated by the deed and executive engineer. He failed to maintain the record lordship. How can I suffer?
Records.
How can I suffer?
Court, you have to call for the record.
Civil court, without I also know.
No, if you are not in a position, this court, for that, this court won't exercise 2 to 6.
From the circumstances, I have completed, that the completion certificate, the alia payment, this
Certainly be, but they have rejected it. Once they reject it, I can. Have you seen any order by which there is a direction passed by the writ court that despite their rejection, the court may at best say that, okay, the rejection may be bad, but then also again direct them to verify. But on what basis?
Yeah. Moreover, my lord, in fact, the rejection they have in the,
It's a
it says in the
question.
affidavit, my lord, but not.
Mr. Gogoi, I do one thing, I won't dismiss it in your hands. I'll ask you to get hold of your senior. Okay. You have a senior, na? As Bottakur.
Yes, sir. Today he's not available.
Let us dismiss it in his hands. What do you say, Mr. Nayak?
Moreover, my lord.
That is one aspect, Lordship. Secondly, matter works pertains to 18, 19, and 20, Lordship. And he filed this petition in the year 2024. So that limitation period is also there. Probably that limitation is not available there. That is why he has filed this petition.
Let us hear him. Let us hear his senior. Because once it is being done, show us any judgments to that effect whereby the court can, when there is an admission, not that there is no admission, then also this court can direct them to make payment.
I found my lord yesterday one authority, lordship.
Mr. Gogoi, if you further argue,
Lordship, my lord, then some other
then
day.
you do it at your risk.
Lordship. Then my lord, some other day.
Mr. D. Gogoi, the learned counsel, on behalf of the petitioner, submits. Senior is not available today. The matter be listed, the date. Mr. Nayak, what about the instructions?
Lordship, I have received the record pursuant to this order of December 2025, Lordship. They have furnished me instruction, or they have furnished actually the record itself. The record, entire record, Lordship. Today,
No,
somehow,
no, that appointment of supervisors.
Lordship.
My question is, how a supervisor is going to look into?
Lordship,
Such a
that,
vast area.
that is part of the contract agreement, Lordship. Under the contract itself, Lordship, there is a provision for appointment of a third-party supervisor. So that was, appointment was made, Lordship, accordingly. But in the petition,
Accordingly, this matter on 18th of August 2020.
Biplav.
18 or 19.
Mr. Lordship, this is regarding my lord payment of premium for settlement of land, my lord. My lord, page 48. The order of approval, my lord, whereby the settlement was allowed, my lord, directed to pay the premium as per notification 21/8/2023.
Now,
thereafter, my lord, page 53, the petitioner has filed an application, my lord, with a prayer to take the premium of rupees 35,000, my lord, which was earlier decided by the circle officer, my lord, and this was on record. Thereafter,
what do they say?
yes, my lord, in the prayer, my lord, it is therefore as per Latmondal report. Then, my lord, the circle officer, my lord, page 55, wrote a letter to the district commissioner, my lord. In the middle portion, it was written, my lord, as per concerned Latmondal report, the value of the aforementioned plot of land is rupees 25 lakhs. Only per biga as per zonal value for the year 2023. Hence, the valuation of 17.5 plus stand at rupees 4,37.500. In the meantime, my lord, the government issued another notification, my lord. I have filed an additional affidavit, my lord, page 60. Page 60. In paragraph, my lord, 1. In respect of the land parcels where RCC house is standing, 10% of the extant zonal value may be paid as down payment for getting such conditional patta, and 40% of the current zonal value as applicable as area premium at the time of grant of NOC for land transfer of such settled land by the way of lease, gift or sale, etc. My lord. Accordingly, my lord, the petitioner submitted another application, my lord, page 62, my lord. He is willing to pay my lot as per this notification, my lord.
So you have an RCC building.
Yes, my lord. There is RCC building.
No, now here, here directing you to make payment as per
Zonal value of 21/8/2023, my lord.
earlier it
Yes.
was 35,000.
35,000, that
Now
was
this has been increased to
4 lakh
37,000.
4,37,000. Earlier,
Where is the land? Lasipara.
Bilaisipara, my lord.
Now say that in respect to the land parcel where RCC building is standing, 10% of the extant zonal value may be paid as down payment for getting such conditional patta, and 40% of the current zonal value as applicable as area premium at the time of grant of NOC for transfer of such settlement. So you have an RCC building.
Yes, my lord.
So you pay now
10%
of the zonal value.
of the zonal value.
So that means here you will pay 43,000.
Yes, my lord, 43,000.
And thereupon, if you sell it,
Yeah, then another 40%.
so they have reduced it.
Yes, reduced it, my lord. 50%, my lord, reduced.
You got it in Mission Basundhara 2.0.
No, my lord, our my lord, page 48, my lord. Page 48. And the minute, my lord, at page 35.
So you don't want, but why the transfer is permitted? What is this type of icon? This type of notification?
The second one, Lordship, 27/12/2024. But this is only applicable in Guwahati and urban areas included approved application for settlement in Mission Basundhara 2.0, Lordship.
Only for Mission Basundhara.
Basundhara, Lordship. And
You are not
only
Mission
urban areas,
Basundhara.
Lordship. No, Lordship. And at that
My
time,
lord, urban area, my lord.
For settlement in Mission Basundhara 2.0.
this is, that will be conditional patta, Lordship, as per my realization, Lordship.
Peripheral area, whenever it is, and refix the rate of residential perimeter at Gauhati and urban areas, including approved population of settlement can be to new payment of yes, please. My lord.
And as per my instruction, the rate of
4,37,000.
My lord, but at the earlier occasion, my lord, the value was fixed at 35,000 only, my lord, page 42.
Do one thing, give back the land. You take back the land.
My lord.
He cancel the patta. Take back the land. You pay him 43,700. Okay.
Sorry, my lord.
So land is now have become such a difficulty.
Yes.
In the way.
Because
it is in Bilasipara town. Then we get this almost one katha of land at this price, 4,37,000. Then why you are not making this payment? First of all, getting payment is a big problem. And getting a land is a big problem. And now you are not making. We do one thing. Give him 30 days to make the payment. If he fails, then cancel his allotment.
Sir.
Mr. Hussain,
My lord.
better off. 30 days you make the payment, else cancel the meter. Because he doesn't have a right, you can't, this has been going on from 2024. We are in 2026.
My lord.
Then cancel it.
Maybe allowed. 2 months may be given, my lord, to pay.
See?
My lord.
Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the Revenue Department. And Das, who appears on behalf of the District Administration. The petitioner, pursuant to an application submitted for settlement of land at Bilasipara town of Dhubri district, was granted a settlement
Yes, 48, my lord.
of 17.50 lessers covered by dark number 771 bracket PT, situated at village Ananda Nagar town under Bilasipara Revenue Circle, subject to realization of the settlement premium as per the government notification dated 21/8/2023. The case of the petitioner herein is at the time when the settlement process application was filed and the process was initiated, the circle officer Bilasipara Revenue Circle valued the land at rupees 35,000.
My lord. Page 42.
And as such, the petitioner ought to have been. And as such, it is the case of a petitioner that a settlement period premium ought to have been at the fixed at the rate when the petitioner submitted the application and the process was initiated. Be that as it may, it is relevant to take note of that pursuant to the said settlement made in favor of the petitioner dated 16/2/2024, the circle officer Bilasipara Revenue Circle informed that the land in question the value was rupees 25 lakhs per bigha, and the amount as regards the settlement made in favor of the petitioner as the premium be rupees 4,37,500. The grievance of the petitioner, therefore, is the petitioner should be only permitted to that the respondent should be directed to accept rupees 35,000 in lieu of rupees 4,37,500. Said aspect having not been considered, the petitioner has approached this court by filing the present writ petition. Also takes note of that an additional affidavit was filed by the petitioner based upon another notification dated 27/12/2024, whereby the payment of the premium in terms with Mission Bosundara 2.0 was reduced subject to issuance of a conditional patta. It is perusal of the said notification reveals that in order to get an unconditional patta, unconditional settlement, 100% premium is required to be paid. The petitioner had submitted a representation on 7/2/2026. However, the same have not been considered. In the backdrop of the above, this court heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Ms. G. Hazarika, the learned standing counsel of the Revenue Department, submits that the petitioner's settlement was not in terms with the Mission Basundhara 2.0, and that aspect would be very much apparent from the records itself. And as such, the notification dated 27/12/2024 does not apply. This could also have taken note of that though the petitioner had submitted the application prior to the government notification dated 21/8/2023, thereby fixing the settlement premiums. But the settlement was made in favor of the petitioner on 16/2/2024, when the notification dated 21/8/2023 was holding the field. Under such circumstances, this court does not find any illegality in the communication dated 8/4/2024, whereby the land which was allotted to the petitioner subject to payment of the premium was fixed at rupees 4,37,500. It is also relevant to take note of that the petitioner's settlement was based upon payment of the premium, which the petitioner till date have not made the payment. Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would make the payment of rupees 4,37,500, which have been adjudged as, which have been mentioned in the communication dated 8/4/2024. Also, taking into account the above, the instant writ petition stands disposed of with the following observations and directions. Number one, the petitioner would be liable to make payment of the premium of rupees 4,37,500 for a settlement of 17.5 acres of land covered by DAG number 771-PT, situated at village Ananda Nagar (town) under Bailasipara Revenue Circle in the district of Dhubri. Number two, it is observed and directed that if the petitioner deposits the said premium of rupees 4,37,500 within a period of 2 months from the date of the present order, the unconditional settlement be granted to the petitioner. Unconditional word? The unconditional settlement of the land in question be granted in favor of the petitioner by issuance of the necessary patta.
God bless.
Yes, Mr. Das.
May please your lordship, my lord. In this case, my lord, it requires some time to obtain instruction whether the petitioner will continue with this petition, my lord, because in view of this the affidavit in opposition filed by the Deputy Commissioner Kamru, my lord. It appears that the authority concerned has already initiated a process, my lord, for eviction of the unauthorized encroachers of the village grazing reserve, my lord. That has come to your notice, my lord, from the affidavit in opposition filed by the state respondent, my lord. That your lordship will find it.
So far as the
Yes.
eviction notice is concerned, my lord, there are 2 writ petitions have already been filed, my lord, challenging that notices, my lord. And thereupon, court has passed interim directions also, so that we cannot take up the process accordingly. Process could not be completed, my. So my prayer would be, my lord, that all the matters may be listed together, my lord. Lordship see the.
The other two,
Yes, my lord, that is page
is
68.
this matter along with
WPC 200/26.
WBC number 10/2026 and WPC number
210 is already disposed.
200/2026, WPC number 200/2026 and 376 of 2026. Okay. On
After a week or.
on 20 August 2026 for final disposal.
May please lordship. My lord, subdivisional land advisory board, my lord, recommended the name of the petitioners for allotment of land, my lord, and send the proposal to the, my lord, BTC. And the BTC kept the matter pending, my lord, neither approve it nor reject, my lord.
Lordship, I appeal for the BTC. Bring Lordship for some more time or to file the affidavit. We've written for instructions. Requiring some more time to file affidavit. Lordship.
Why? 2
Lordship,
years is not enough.
Lordship, on the last occasion, we had taken time because
Then
she will accommodate us for one more day, Lordship, positively within 2 weeks.
a final opportunity is granted to the BTC to provide instructions as to why the petitioner's application seeking settlement,
No recommendation, already recommended by the, my lord.
seeking settlement, which have already been recommended by the Land Advisory Committee, have not been adhered to, have not been considered till date. To provide instructions, petitioner's application seeking and already recommended by the Land Advisory, not been considered. This matter on 12th of August 2026 is observed that in the circumstance the BTC authorities do not provide the instructions, this court shall be constrained to call the concerned official responsible, relaying the information to this court, providing information.
Obliged, my lord.
Pertains to settlement of a particular fishery, my lord. My lord, admittedly, my lord, I am the second highest bidder and private respondent is the 4th highest bidder, my lord. Lord, in fact, my lord, there is some defect in the, my lord, in submission of tender, but without considering the defect, my lord, as per NIT, my lord, settlement has been granted, my lord. My lord,
You have not been granted.
no, my lord, in respect of respondent number, private respondent, my lord, has been granted.
Is the third,
Fourth, he is 4th.
you are number second,
I mean, we are second,
you have not been granted.
not been granted.
Lordship, Lordship, he has given the 2018 notification, Lordship. That notification actually he is not, he has not covered that notification that the individual Fisherman certificate he has given. In that case, Lordship.
His was cancelled.
That is the reason, Lordship. Lordship, I may be allowed to bring all the records, Lordship, on the neck.
Mr. P. Sharma, the
Record
learned
may be
counsel,
granted, my lord. Record may be granted. Record may be called for, my lord. Record.
is what I was about. Mr. P. Sharma, the learned
Yes, Lordship.
submits that he would like to produce the records, the basis of which would show the reason as to why the petitioner's bid was not considered.
Lordship.
And the respondent number 4 was with the settlement. Taking into account the above, list this matter 3rd of September 2026
Lordship.
for final disposal. Records be produced.
Highly obliged.
Highly obliged.
May I please, your lordship. Lordship, here the petitioner's name, lordship, were recommended for settlement, lordship, by the land advisory committee, lordship. Subsequently, lordship, some persons, lordship, they were.
Right, the affidavit has been filed by the
Yes,
respondent. What do
lordship.
they say? Do they say?
They have filed, lordship, affidavit.
Then have filed an affidavit. The land advisory covered by two, as per the report of the subcontractor. The statements are true. What? The proposal was recommended in the he had submitted on one wherein he had complained that he and party. Wait for this Rubul Amin.
Ruhul Amin, lordship, they are
The
claiming,
party.
I have made them party, lordship, but court said that since I am not seeking any relief against them, so strike out their name, lordship. I have made
Name
them
will be
party.
struck off.
Yes, lordship, on the first day itself, lordship. I have made them party, lordship, even their names are there.
You do one thing. We have to have him.
Yes, lordship, I made them party, lordship.
In it. We don't need others. We only need Rahul.
Ruhul Amin.
Whom do we need? As per the affidavit.
This Ruhul Amin, he filed that.
Ruhul Amin.
Okay.
We make him a party. Huh?
I'll file an impleadment application. lordship.
Support. Submitted by Rustom Ali.
Rustom Ali,
Ali is also party.
yes, yes,
Huh?
I made them party. They are all sons of Wahab Ali, lordship, these 5 persons. 5 to 9.
Rustom Ali. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. So-and-so. Petitioner appears for the district administration, P.R. Mohanto. The government of Sam. Petitioner herein, petitioners or petitioner?
Petitioners, lordship, petitioners.
Capital.
Two petitions.
The petitioners herein have approached this court by the inaction on the part of the respondent authorities, not granting the settlement in the petitioner's favor. in spite of the Subdivisional Land Advisory Committee have recommended settlement should be made in favor of the petitioner. It is also seen that at the time when the writ petition was filed by the petitioner, the petitioner had arrayed the respondent numbers 5 to 9, who are all the legal representatives of Wahab Ali. However, this court, by an order dated 14/2/2025, has struck off their names on the ground that they are neither necessary nor proper parties to the writ petition. This court further finds it relevant to take note of the affidavit in opposition filed by the respondent number
3, Lordship.
wherein it is seen that the respondent number 3 had carried out the hearing on account of certain petitions which have been filed by the respondent numbers 5 and 6. And this aspect of the matter has been mentioned categorically in the affidavit filed by the respondent number 3. Considering the above, it is therefore the opinion of this court that as in view of the affidavit which has been filed by the respondent number 3, the presence of the respondent numbers 5 to 9
Namaste, auntie. Namaste, uncle. Subject.
the respondent number 5 to 9 assumes relevance as they are not only proper but necessary parties to the present proceedings. Accordingly, the respondent number 5 to 9 who were initially impleaded, their presence are necessary as they are not only proper parties but they are necessary parties to the present petition. Accordingly, this court impledes the respondent numbers 5 to 9, impledes Rahul Amin, Rustam Ali, Zubair Ali, Bakar Ali, Imdadul Haq, all sons of late Wahab Ali and resident of village Bhuktapuri, E.O. Sipazar, in the district of Dorong, Assam, in 784145, as the respondent numbers 5, 6, 7, 8, and 9 to the accompanying. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order as well as the fresh memo of parties, make necessary correction in the cause title of the writ petition as well as update the same in the CIS. Next. Issue notice upon the respondent numbers 5, newly included respondent numbers 5 to 9. Steps be taken by way of speed post within 3 days. In addition to that, the petitioner is granted the liberty to take steps by way of dusty.
Dusty will not be possible, Lordship. They will not accept notice from me. Lordship.
That's a different thing.
I'll
But
take,
we
Lordship.
can proceed further.
Yes, Lord. Yes, Lordship.
Grants the liberty to the petitioner to take steps by way of dusty to the registry of the court upon the respondent numbers 5 to 9, newly impleted respondent numbers 5 to 9, to the registry, routed through the registry of this court and file an affidavit of service on or before the next date. List this matter again on 9th of September 2026.
I oblige.
In this case, my lord, my affidavit is already been prepared and is ready, my lord. Only it has gone for the vetting. Can it be taken after 1 week, my lord?
Is a matter?
My lord, two
Oh,
plots
so
of
that
land.
day, matter came up last Friday, na?
Yes.
Wednesday, isn't it? Yes,
Maybe.
Wednesday. So
there the
you made
allotment
a
orders are
submission
there,
that all similarly situated persons
have been given
granted,
patras.
and you have not been.
By, yeah, we, the two have not been given.
Although settlement granted.
No, allotment
settlement.
has been done.
No settlement.
Allotment has been
Allotment
provided.
is only
Settlement and patra has not been issued.
You have paid the premium.
That was not ordered, madam.
Huh?
Kindly see page 15.
Been allotted in your favor to possess them. Terms and conditions, first page. No, they are not. This is an allotment, it's a different thing. Maybe treated as exonia, media, may not be treated. No, this is mere. Have you applied for allotment, settlement?
Settlement,
This is just only for remaining there. This is a permission.
actually at that same time, several other persons were given similar order.
Understood, but Mr. Mahmood, this is merely a permission in terms we can bring it within the ambit of Rule 16 of the settlement rules. You are to apply for allotment.
Settlement.
That must be their stand, isn't it?
Yes.
Then Lordship may kindly grant that liberty. Within a particular time, we will apply and they will issue settlement and patra within thereafter, after 2 weeks or 3 weeks.
Huh?
We will pray for settlement and issuance of patra. And if we pay the premium as ordered by the authority, then they
You will apply. After you apply, they will consider. Then they will grant you settlement, subject to payment of premium. Once you pay the premium, then you get the unconditional settlement. This is the process.
Yes, madam. That,
But here, as of now, the first stage have not started.
but we are apprehending that we may be evicted, my lord. That is
So
why
you-
some
you are-
protection may
you
be
are
committed.
evicted. Are you asking
Not
that,
evicted,
saying
but
that?
there is apprehension. We have clearly mentioned in our petition because
Yeah.
kindly see page 12, paragraph 15.
They shall not be evicted without, give you, in the meantime, go for file application. Now, Mission Bisandara 4 is going to happen. Or 3.
Three, my.
Going on.
It's already over. 3 is already over.
Now 4.
It yet to be started.
Anyways, the petitioner can very well file an application for settlement. Once they file the application for settlement, then you will consider.
Exactly our stand is also that man.
Huh?
Exactly that our stand is also that man. He
Sure.
did not approach man.
You have not asked for settlement till now. So what to do, Mr. Mahmood?
Yes, Lordship may kindly grant that liberty.
Which one?
We will file an application.
You are always at liberty. Then the next one,
Same thing. Same. So, similar matter. Next one means petition number 2.
No. In this petition itself. You see, you can be evicted only by way of
Rule 18.
issuance of notice.
Rule 18.2.
No notice has been issued.
No man.
No.
Notice is issued, then you may be given an opportunity to duly place your materials one. As regards application for allotment, you can very well apply for it. Then there's another petition.
No. Here are 2 petitioners.
The petitioners herein are so and so, so and so. The petitioners herein have approached this court, taking a direction upon the respondent number 2 to issue settlement orders in favor of the petitioners in respect to the lands allotted to the petitioner by DAG number 286 situated at village Nidhanpur Part 2 under Lokhipur Revenue Circle in the district of Gwalpara, Assam, as per their respective possession. As well as other consequential directions. The petitioner also apprehends that the respondent authorities having not granted the settlement till date, may take steps for eviction of the petitioners from their respective possessions. This court had perused the materials and record, including the documents whereby the petitioner, by whom, whether it was given to the petitioners or to their predecessor in interest.
My lord, 2 kata was provided to petition number 1 and 3 kata 15 lesser to petition number 2.
Whereby permission was granted subject to the terms and conditions of the document, namely, bracket or inverted comma, aborton potro. For occupying the land which the petitioners are presently under occupation. There is a distinction between the said document aborton potro with a settlement to be granted, inasmuch as for the purpose of granting a settlement, there is a requirement of filing an application, and thereupon such settlement shall be granted subject to the policy of the state, which at present is the Assam Land Policy of 2019, and payment of the necessary premium. The petitioner admittedly have not applied for settlement under a bona fide belief that the said document, namely aborton potro, is an allotment so granted to the petitioner. Mr. Amu Mahmood, the learned counsel appearing on behalf of the petitioners, submits that the petitioner would apply for settlement, and if such application is made, the respondent authorities should be directed to consider the same as per law. The learned counsel for the petitioner also submits that in the meantime, the respondent authorities, taking into account that the petitioners have been in occupation of the lands after being duly permitted to possess the said lands, the respondent authorities should not evict the petitioners from the said lands. This court also heard Mr. N. Das, the learned government counsel who represents the respondents, who submits that the document aborton potro cannot be said to be a settlement, and for that there is a requirement of a process. Considering the above, the writ petition stands disposed of with the following observations and directions. 1. The document, namely aborton potro, which have been issued in favor of the petitioners on 4/4/2007, which are as enclosed is Annexure 1 and Annexure 2, grants permission to the petitioners to reside over the land described in the schedule to the said documents. Number 2. Number 3. The said document, however, cannot be said to be a settlement of the land. Number 2. The petitioners are granted liberty to file appropriate applications for settlement in accordance with law. and as per the practice followed. It is observed that in the circumstance such application is filed, the same be considered within the purview of the Assam Land Policy of 2019. Number 3. This court further observes that in view of the document nately aborton potro, as the petitioners have been permitted to reside over the lands in question, as mentioned in the schedule to the said documents, the petitioner should not be no steps for eviction of the petitioners be carried out without following the due process as settled by without following the due process.
Highly obliged, madam.
Wait, please, Your Worship.
In this case, we are yet to receive our extra copy.
No, just applied, my lord, but no final conclusion was made, my lord. No, no. There, my lord, still status is, my lord, not shown, my lord. They have not called, my lord.
Why you are not granting permission for marriage?
Lordship, actually, although notice was issued, we are yet to receive the extra copy. In fact, our letter was ready, but we could not send it.
What?
Yes, Lordship. They did not provide us the extra copy.
No, my lord, we have extra.
The application validity has also gone.
No, there is an order by this court, my lord.
Yes.
So,
Would not come in the way as the repetition will before the expiry. But why haven't you taken steps?
my lord, we'll supply, my lord.
With due respect, I beg to state the above mentioned has not been listed on here since the matter has not been kindly list the matter on so and so for admission.
Last occasion.
All these are done, but my question is why haven't you taken steps?
I'll supply copy when next time.
Mr. Ziuddin, the learned counsel appearing on behalf of the petitioner submits that extra copies of the writ petition be served upon the respondent numbers 1, 2, and 3 by tomorrow. Taking into account the above, list this matter on 19th of August 2026, on which date the respondents shall provide an update as to why the petitioner's application dated 21/6/2026 have not been accepted by the concerned respondent authorities, thereby permitting to solemnize their marriage in terms with the Special Marriage Act 1954. But if you don't provide the copies tomorrow.
I'll
Obliged.
Yes.
May I please, your lordship? Lordship, here lordship, one Sitara Banu Bibi, who is the pattadar of a plot of land in Kachar district, she died leaving behind 3 sons and 7 daughters, lordship. And out of that, after her death, 4 of her legal heirs' names were mutated, and thereafter her name was deleted, lordship. So, her other legal heirs submitted application for mutation to the to the settlement officer, and accordingly, settlement officer issued a letter to the assistant settlement officer at page 19, lordship, to issue summons to all the pattadars who wants to all the legal heirs who wants to get their name mutated. So ultimately, he did not issue summon to any of them, whether to those whose names are already mutated, nor to those who wants to get their name mutated. So ultimately, when the notice was issued in this matter, they have produced one report of Lot Mondal by way of affidavit, lordship, which says that the legal heirs are not in possession. The legal heirs, that is the petitioners in this particular case, are not in possession. However, our case, Lordship, is mutation by inheritance. So in case of mutation by inheritance, in terms of 411 and 400 and
Who is in possession?
possession, three of my sons, three of my brother. There are total 10 legal heirs are there. So out of the 10, we are the sisters, Lordship. So the brothers, they are in possession. It is not that they are making any objection against our possession, Lordship. We are married daughters. We are staying somewhere else. We have constructive possession over the land, Lordship. So physically, we are not staying there. So in case of
So your names have not been mutated.
not been mutated because and
Has it been cancelled?
no, not cancelled. Difficulty, Lordship.
The affidavit has spelled out two things. Number one, that petitioner number 1 to 11 is not in possession. That is of course a matter of finding of fact. But more importantly, that their mutation has been stopped due to ongoing digitization of land records. However, action for process of mutation could be initiated after completion of the digitization works. So this is the reason why, my lord, their names have not been mutated. Precisely that.
First of all, if they are brothers and sisters, unless there is a partition, owners do not have a right of adverse possession. Owner's possession is always considered to be a possession of all owners.
Yes, yes.
So therefore, possession or not, it is immaterial if it is some brothers residing on. So that has no meaning. But as regards the digitalization process,
yes, madam.
The digitalization process is one thing, but this is of 2025.
2025.
Are you installing all processes? My question is this.
That
Very difficult to answer that. So we need give an update as to why the mutation has not been carried out or carried out and finish it off within 1 month or 2 months. Isn't it?
Because this affidavit was filed in the month of December 2025, almost my lord, last year.
Yes, 6 months down the line.
6 months
So
down the line.
therefore,
So
you
perhaps,
carry
my
out the
lord,
mutation and finish it off.
Yes.
What is there?
yes, ma'am.
Petitioners herein.
Only one submission, my lord. Let the petitioners appear before the district commissioner and let the petitioners appear before the district, because this affidavit is filed by the district commissioner. Let them appear before the district commissioner with all credentials within the time bound period, my lord. Let him be satisfied, my lord.
All you are all brothers and sisters.
All brothers and sisters.
Have come together.
Yes.
Some are in possession, some are not.
Brothers are in possession, sisters are married. Yes.
Some are in possession, some are not.
Yes. Physically.
This was your case.
Yes. Said
The petitioners herein who are who are you brothers and sisters? Some are son of Nina Mia Khan.
No. Lordship will see page number 17. Page number 17. These are all the legal heirs of Sitara Banu Bibi. These 10 people.
Who are they?
These 10 people, three daughters and 3 sons and 7 daughters. These are the legal heirs of Sitara Banu Bibi, the original Pattadar. Now these people have also expired, Lordship. We are the sons and daughters of these people.
Of?
These people, Lordship. These 10 people, page 17, Lordship.
So Sitara Banu Bibi was the original one.
Our grandmother.
The original one.
They say, my lord, she is the original predecessor in interest. Now the genealogy has not been as such spelled out in the writ petition. Statements are there. Therefore, I have made a submission.
These facts are admitted. Page 19, Lordship. Page 19, Lordship will see the settlement officer has narrated the entire facts based on record, and thereafter he directs, Lordship's last para, Lordship. However, you are page 19, Lordship. He has recorded the facts from the record, Lordship. In inviting reference to your letter.
Page 19?
Page 19 of the writ petition.
Yes.
In inviting reference to your letter under reference, it appears from your report that second arrest record names of so-and-so, 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 so-and-so brothers, sons and daughters of so-and-so has been recorded by virtue of inheritance by the order dated 15/6/17 passed by the then SDC in the name of Sitara Banu Bibi has been deleted thereafter. But as per next of kin certificate issued by the circle officer, the name of legal heirs of Sitara Banu Bibi is 1, 2, 3, 4, 5, 10. As per the enclosed record, it has been found that the name of 1, 2, 3, and 4, 5, 6 has not been mutated in second RS record by virtue of inheritance. However, you are requested to summon the persons whose names are to be recorded in third RS record by virtue of inheritance of their deceased predecessor to produce records, if any, in their hands, so as to ascertain that the person whose names are not reflected in second RS record already sold out their share of land or not, and only being satisfied at your end that no such incidents of disposal of share of land already took place, name of the legal heirs may be mutated, updated. Thereafter, this process has not been carried out, Lordship. Only after issuance of notice, they have enclosed this report of the Mondal in the reply, Lordship. That we have no possession.
And in the meantime, during the my lord third resettlement operation, that plot number has also changed. That we have spelled out in paragraph 5. my
Anyway,
lord.
lot number has changed from what to? Area has changed and consequently dark number so and so.
Yes, dark
pertaining to
number,
So
sir.
and so has now been brought under town block number 1, block number 176.
Absolutely.
Have not been found in physical possession of area. Now, who is in possession?
That has not
Some
been
of
spelled
them
out.
are there, Lordship, whose names are
No,
muted.
no. These are very important.
Yes,
It
yes.
says everybody,
No, no.
Petitioner number 1 to 11.
all the petitioners.
All the petitioners. That is
Therefore,
what my,
there is nobody in possession.
that
No,
is
no,
what my affidavit says.
the people whose names are mutated, they are in possession. Paragraph number 1, Lordship, it appears that Turfan Ali, Sukur Ali, their legal heirs are in possession, Lordship. Their legal heirs are in possession. Turfan Ali, Sukur Ali, Manohar Ali, and Harunena Bibi. Their legal heirs are in possession.
Who are in possession?
Page
They are
9,
not the petitioners.
they are not the petitioners.
So therefore, these are the petitioners whose possession has not been recorded.
Yes,
They are not, but they are co-owners
owners.
along with the others.
Yes.
Total 18 persons.
Total 18 pers. We here, Lordship, now
this-
before your Lordship, only 11 have come, Lordship. All have not come, Lord.
This late Sitara Banu Bibi, she was the original predecessor in interest. She died. Thereafter, my lord, this part and parcel of plot of land devolved upon the immediate, my lord, generation, sons and daughters. These are the third generation. They say, my lord, some of their predecessor and immediate predecessor in interest names appear in the revenue record. My predecessor in interest name doesn't appear. As such, my name should also be recorded. This is such one. So therefore, they will have to lay down the genealogy and get the district commissioner
That I
satisfied.
understand.
That
That
much.
the circle officer will.
Yes, that much.
At the circle officer or the estate settlement.
Because I also could not my lord, specifically figure it out from a bare reading of the writ petition.
11 petitioner who claimed rights over a plot of land covered by tag number 565, 566, 567, 568 pertaining to the second RS Patta number 191. Which has now been brought under town block number 1, block number 176. On the basis of being of inheritance being the legal representative, legal heirs of one Sitaram
Banu Bibi.
Sitara Banu Bibi.
Banu Bibi, who was the original owner of the said plot of land. Grievance of the petitioners herein is, though these petitioners sought for mutating the name in the revenue records, by filing an application before the respondent number 4, However, the said process have not been proceeded with by the respondent number 4 and on account of the delay and inaction on the part of the respondent number 4, petitioners being aggrieved have approached this court by filing the present writ petition. Court duly takes note of that these applications were filed in the year 2025. Isn't it?
Yes.
25, 3/3/25.
Sitara Banu baby, she expired in the year 1970 and the death certificate was obtained on 28th of February 2025. Immediately thereafter, the writ
In
petition.
the year
No,
2025.
applications filed on 3/3/25.
And-
Page 18.
Question as such, as per the provisions of the Assam Land and Revenue Regulation 1886, the respondent number 3 and 4 ought to have proceeded with carrying out the settlement operation, taking into account that at present the third revenue settlement proceedings are going on. Now the third revenue settlement proceedings are going on.
My lord.
Considering the above, this court therefore disposes of the instant writ petition without without deciding anything as regards the rights of the petitioner to have their names included in the mutation records bracket comma, which aspect the respondent number 3 and 4 shall duly decide. The respondent number 3 and 4 are directed to take effective steps for an early conclusion of the said mutation proceedings, and preferably within 4 months from the date a certified copy of the order is served upon the respondent number 3.
Obliged.
On 3 or 4.
Respondent number 3.
Let it be
Three,
my lord,
three. Settlement
He is the settlement officer.
Obliged.
And sir,
Primarily, there are three issues. The first issue is whether the search and seizure in this case was strictly in conformity with Section 67 of the Assam State GST. The second issue would be that whether under Section 67 or otherwise, during a search, the respondents were entitled or empowered to recover portion of the tax without first there being an assessment or there being an order or demand. And the third issue would be the sanctity and the effect of a consequential notice issued under Section 70 of the Assam GST when the search itself was not in conformity with the Act. These are principally the three issues, and there are certain sub-issues within the first issue. That is, whether the search warrant itself was issued as per the rules prescribed, whether it was issued
So you
in
have challenged the search.
I have challenged the search, the consequential proceedings initiated under 70 after the search.
70?
70 basically empowers them to issue me a notice for initiating the process for the purpose of assessment. It's a summon.
What act?
Assam State GST. So first, what has happened here? First, there is a search, which is under 67. Now, while this search is on, there are allegations which I have made that I was detained, etc., etc. Now, during this search, they recover a portion of the tax. So, the search, in my respectful submission, the search was not preceded by an assessment or an assessment order or a demand. There was a search, all of a sudden there was a search. During that search, they said that there is an X amount of GST liability, and they said that you please pay a portion of it immediately, otherwise we'll continue searching and we'll keep you detained. So a search happened under 67. The second part of it is during the search, a portion of the GST claim or the GST liability was recovered along with professional tax. So the second challenge is the recovery itself, 6.5 crores which was recovered. And the third challenge is the notice under 70, that is the show cause notice or a demand notice or the summon. Because what I am trying to say is that you could not have first conducted a search and then issued a notice under 70. Well, there's I must point out here, well, I am a little handicapped today, my lord. Why? Because my instructing attorneys could not make it. They were supposed to come from out of town. They could not make it in the last one, but these are broadly the three issues in the writ petition.
Section 70 is power to summon sir to give evidence and produce.
Yes, which in this case happened after the search. In my case, what happened? Under 67, a search took place.
Now,
A
what
search
has
was
happened subsequent thereto, the proceedings under 73, 74 have not been initiated?
no.
No, my lord. Till, my lord, as on date today, I've got updated instruction, my lord. Under section 70, my lord, that proceeding is on. They are cooperating, they are participating, my lord, they are furnishing new information to us.
No, we are not going to stay this
Yes.
recovery notice, huh? We say that whatever may be, they may initiate all steps, whatever may be, final order can also.
They will have the right to challenge it, my lord, if they agree.
Well, there's
No,
they are
Mr. Counsel,
participating.
this interim order is wrong.
no.
And one more thing may I point out, my lord, so far as the, my lord,
I will
payment,
no, Mr. Counsel.
May only point.
No, sorry. The search was made when?
yes,
Search was made, my lord.
it was on, my lord, 29 July 2025.
29 July 2025.
Yes.
And someone was issued, my lord. which is
Someone was
issued
issued
on
6/9/2025. 6/9/2025.
6/9/2025.
After all this, my lord, input tax credit, my lord, that came to light. That there was
Okay,
some,
no. 6/9. Search was on
29/7/25.
29/7/2025.
It continued till 4/8/2025.
Okay, 4/8/2025.
And the summon was on 6/9/2025. Now, just one more date.
4/8.
I'm sorry.
Search
Continued till 4/8.
4/8/2025. Someone was issued on section.
Prior to that, my lord, on 5/8/2025,
5/8/25.
I deposited 6.5 crores, which was not deposited, it was recovered during the search.
No, not prior to that, after the search.
It was because the search went on till the 4th. On the 5th, when the search was continuing, my averment is that I made the payment on 5th and the search immediately stopped.
that was a
So,
voluntary.
so you deposited 5.85
6.5 crores
on 5th, 6.5 crores.
on 5/8/2025,
And then
which was under protest. And on 6/9/2025 is the summons under section 70. Now, for a moment, my lords will see the interim order that's operating in this matter. Just for a moment. 3/9/3/11/2025.
accordingly, though the authorities may proceed in terms with the however, no final.
Only the final demand has been, so it's a limited
no
protection.
final demand recovery notice. What is this recovery notice basis?
but-
No, Mr. Counsel, let us go by this. What is this concept of a recovery notice? Can there be a recovery? You practice GST?
Well, not
No, you
completely,
practice GST, I suppose.
Yes, I have an idea of.
Now, if you have an idea of it, Tell me, can there be a recovery without the issuance of a notice under 73 or 74?
No.
No. So therefore, you're stalling the issuance of the notice. Moment you are stalling the issuance of the notice, you are affecting on 73(9) and 74(9). I think this will be a case under 74(9).
Yes, ma'am. 74.
It's a case of 5 years.
Yes, yes.
It's a
So
case
then
of-
why should we may very well say, do whatever you want. Pass an order in original also, but don't make a recovery of any amount pursuant to any final orders being passed under 73, 74.
Very, very. I'm not.
So that is what,
I'm not
because you see, the problem which arises, Mr. Counsel, is this. In service tax, you have the limitation on the notice. GST, you have the limitation on the order.
Yes.
There you have that is the problem. The moment you are issuing a notice or stay of a notice out there, not to issue a recovery notice or a demand notice out there, means they cannot issue a section 73 or 74 or even a DRC, not DRC, not GRC 1. You may cannot issue even a DRC 2 under 73.5, which is being issued, or 74.5.
Three.
DRC 3. They can't even issue a DRC 3 asking you to make the payment. The moment they issue this will be in violation. So let them do whatever it is, but not to make any recovery pursuant to any orders being passed
Ma'am.
after 73, 74.
Well,
It's a better order.
well,
Ma'am.
Mr. So in the meantime, we can take up the matter for final disposal any day whenever
Yes.
it's convenient.
yes. Anyway, can we report?
Heard Mr. So-and-so, your name?
K Talukdar.
K. Talukdar, the learned counsel appearing on behalf of the petitioner. P. Gogoi, the learned. He who is also the standing counsel of the Finance and Taxation Department of the Government of Assam. The present petition has been filed by the petitioner, assailing the search which was conducted in the petitioner's business premises from 29/7/2025 to 4/8/2025. Semicolon. The recovery of the amount which the petitioner made under protest on 5/8/2025 to the tune of rupees 6.5 crores, as well as the issuance of the notice dated 6/5/2025 under section 70.
6/9. 6/9/20.
6/9/2025 under section 70 of the Assam GST Act 2017, whereby the petitioner has been asked to produce evidence, have been summoned to appear and adduce evidence. Affidavits have been filed on behalf of the Finance and Taxation Department of the Government of Assam. And we have filed reply also, Mr. Counsel.
Yes.
And replies have also been filed by the petitioner. This matter would require a hearing be carried out as regards the legality of the search, recovery so made, as well as the issuance of the notice under section 70 of the Act, AGST Act 2017. Be it as it may, this court, upon hearing the learned counsels appearing on behalf of the parties, of the opinion that there is a requirement of modification of the interim order which was passed on 3/11/2025. For the reason that if there is no modification being carried out, the interim order which is being passed would have an impact on the very adjudication of a proceedings. initiated based upon search, taking into account the limitation period so provided under section 7410, 7310, bracket 10, oblique 7410 of the AGST Act 2017. Accordingly, this court therefore modifies the interim order passed on 3/11/2025, thereby observing that the pendency of the instant writ petition shall not bar the respondent or authorities to initiate any proceeding based upon the search as well as the search and the seizure so carried out. And pass appropriate orders in original in terms 23 oblique section 74 and or section 74 as or section 74 of the AGST Act as the case may be. However, such orders so passed shall not, however, no recovery thereupon shall be carried out on the basis of such orders passed under section 73 or section 74 of the AGST as the case may be.
Lordship also indicate section 70 also, summon proceeding as well as seizure.
That everything allowed. You can very well go ahead, everything. So therefore,
Lordship will indicate the section, madam. Seizure proceeding as well as the summon proceeding will go ahead.
I've allowed everything. So on the basis of the search and seizure,
Yes.
as well as
Summon
the
proceeding.
summons so issued under section 73, however,
70.
70. Only 73 order, if you are passing, you don't
Implement it, my lord.
implement it. That is why.
I'm grateful.
List this matter again for hearing when.
Any others will go, we will go ahead with the proceeding, my lord. Lordship will fix a date for hearing. Sometimes
On
September.
August, my lord.
when?
In August, if not inconvenient.
Yes,
After
August.
Independence Day.
27th August?
Lordship.
I'm grateful.
27th August. At 2
I'm
p.m.
good.
for final decision.
At 2 p.m. I'm grateful.
Yes, any urgent matters?
My lord, item number 52 has become infrastructure regarding freezing of bank accounts. It is a series, one of the series is there from item number 46 to 52. My now item is 52.
46 to 52.
Unfreeze.
42 is
5 to 52. Because
42 to 52.
46 to 52.
What has happened in that?
My item is 52, my lord. My account has been freezed, my lord. I have approached this honorable court during the pendency of the case, my lord, the unfreeze. Infrastructure.
Same 52 from the Oxo. Your case is?
2441.
Your client name?
Because Soikia.
Heard Mr.
S. Hazarika.
S. Hazarika, the learned counsel appearing on behalf of the petitioner. The counsel for the petitioner submits that the petitioner's bank account bearing number 404316364447 maintained at the State Bank of India, Bazaar branch, Nagaon, was freezed on account of a disputed credit of rupees 963. Mr. S. Hazarika, the learned counsel appearing on behalf of the petitioner, submits that pursuant to the filing of the instant writ petition and the notice having been issued, the freeze upon the petitioner's bank account have been lifted, and as such, nothing further survives in the instant proceedings. Accordingly, the writ petition accordingly, the learned counsel therefore submits that the petitioner is not inclined to further pursue the present proceedings. Accordingly, the writ petition therefore stands closed.
Item number 53, lordship.
Wait. What about other matters from 46 to 51?
Lordship, I am not 51, lordship. Can we fix date, lordship?
What is the matter about?
Lordship, it is a bank freeze matter, lordship. Account freeze matter, lordship.
Okay, let me take up the bank freeze, all the matters, wait. 46. Well, just wait. Let me finish it. This bank freeze has to be urgently fixed. What happened in 46? What has happened? Who is there?
Lordship, in this case, your Lordship, I'm here.
There?
Yeah, Lordship.
What is your matter about?
Lordship, my account also freeze. Subsequently, it was defreeze, your Lordship. Now the amount which is disputed amount is keep on lend, your Lordship.
That's likely. You can't allow you be used. Subject to orders being passed. Who appears for the respondent?
Respondent was directed to file affidavit, your Lordship.
No, not necessarily.
46, Lordship, I'm paying for the State Bank, Lordship.
Respondent, which branch? Union Bank.
Union Bank.
Union.
Rightly. Where, let us see your case. Wow, what is the disputed amount? That some unknown person.
Lordship, here two
Nephews
petitions
of
are
the
there.
husband of the petitioner through some unknown persons made UPI payments on so and so amount to the account of the petitioner number 1.
Lordship.
On Maya came to the petitioner with an amount of his in cash to be credited to his account by so and so. So, how much amount has been kept on hold?
In petitioner number 1, your Lordship, 49,000. 49,000.
49,000.
49,000 something like that.
5,000.
No, 65,000 is the person who gave me. Out of that, 49,000 is the disputed amount in petitioner number 1. And with respect to petitioner number 2, his disputed amount is what? Same amount, your Lordship.
Huh?
What
For releasing an amount of rupees 49 to her and further paid for releasing an amount of AR to the petitioner number 2. Immediately the respondent number 5 of the order to the bank, but the same could not be furnished. Bond nothing doing. This is a minutes. So they have kept on lien, no?
They have kept on lien, your Lordship.
49,674.49.
That's it.
And 49,674.
That's it.
For the petitioner number 2.
Lordship.
Now, why have you approached this court? There's a complaint.
Lordship, there is a complaint laws in the. Lordship may find the complaint at page number. 2 complaint laws, your Lordship, at page number 20. One is.
Now, what is this order at page 27?
Page 27 is, your Lordship, the complainant approached before the 27.
Now, this is a question which cannot be done. Therefore, releasing here. And why one petitioner, 2 petitioners have joined together to file?
There is a connection between them, your Lordship.
Huh?
What happened? Petitioner number 1 husband is a CSP operator, your Lordship. Bank correspondent, your Lordship. CSP operator. He is a.
Who is petitioner number 2?
And petitioner number 1 come with 50,000 rupees to be deposited in his account. Since there is a restriction in the CSP to deposit at one time, Lordship, 50,000, there is a restriction, your Lordship. So he asks his petition number one, husband of the petitioner number one asks his wife to deposit through UPI in the account of the petition number two.
And why have you made
And
response
that
number
amount
5
has been kept,
Shubham Goyal?
Lordship. He is the complainant, Your Lordship.
But how can this court decide as to whether that has been rightly done or wrongly done? This is subject to investigation to be carried out by the officer in charge, Nandagram Police Station, Khasra.
Lordship.
Then,
But
not possible. Can't help you with this. They have defreezed your accounts.
they have
They
different
only put a lien.
Lordship.
Be subject to further orders.
Now, pursuant to this order, Your Lordship, Lordship may find it page number 36. They are demanding that money, Your Lordship.
What?
They are, Lordship may find it page number 37, Your Lordship.
Now, what does it say?
May I read, Your Lordship? Therefore, no claim has been made by anyone other than applicant, nor there is any other claimant to the amount in question at this stage. So,
What is this? This is by court HCGM Ghaziabad.
Ghaziabad.
Full swell. In the light of their aforesaid judgment, it is right to the following. Bond for remand and once you take the lie you mentioned for the. Who is the applicant here?
Applicant is the complainant, Your Lordship. Shubham.
Okay. We do one thing, we'll deal with this matter on some other day.
Lordship.
You file your affidavit.
Let them file their affidavit, Your Lordship.
You file your affidavit. List this matter whenever can you file your affidavit? The counsel appearing on behalf of the Union Bank of India submits that the affidavit would be filed within 7 days. List this matter on 17th of August 2026. In the meantime, the affidavit be filed on or before 10th of August 2026. Liberty given to the petitioner to file a reply therein. Yes, what about 47?
47, Your Lordship, our account has been defreezed completely. Our prayer is simple that the disputed amount is 63,649. Let that be put on lien and we can operate account and the rest of the balance. Presently in our account, there is 83,000 rupees. According to the complaint made in Idathala, Kerala, the dispute is regarding 63,649. So let a lien be put on that and.
The judgment did you? We pass that. Who is the other side?
I'm preparing.
So we dispose it of, keeping a lien on the 63,000. And remaining allow him to
I may be, Lordship,
which
I think I may be allowed to file this affidavit.
not necessary. The dispute is 63,000. So keep a lien on that. You don't allow that, but rest allow the bank account to be here. Keep this 63,000 subject to further direction passed by the investigating agency. This is what I pass an order for this. Okay, now what about 70, 48?
Item number 48, 49.
What?
My senior is not here.
Who are you?
Due
What is
to
your
water
case?
logging in Hatigao.
Put the bank account on hold on the ground that there is a disputed transaction.
48, 49.
48. What do you say?
Lordship, we just need a week's time to file our affidavit because there are almost 41 FIRs in respect of this particular account. The last 2-3 weeks, there have been some transfers in the bank for which the concerned officials were not there to give us instructions.
Counsel for appearing on behalf of the petitioner, respondents, 2 weeks time for filing their reply. This matter on 17th of August 2026. Affidavit be filed on or before 10th of August 2026. 49?
Lots of similar prayer, Lordship.
What is this? Same. Same. 50?
Same prayer.
Same. One.
Lordship, I'm 51, Lordship. Lordship, there is no any disputed amount, Lordship, in my account. There is no any disputed amount, Lordship, but bank authority freeze my account, Lordship.
Why?
I don't know, Lordship.
Lordship, we need some time to file our affidavit.
When was it freezed?
Manager, Lordship, did not furnish any details, Lordship.
No, it's
Why?
okay. When was it freezed?
Lordship, that's why I don't know, Lordship.
Okay. Same, no, we have it prior to that. You get your instruction. List the matter on 10th of August 2026, on which date the counsel who represents the respondent numbers 1 to 4 shall apprise as to whether there is any amount disputed which have been, as to why the petitioner's bank account has been put on hold.
Lordship.
Any urgent matters?
Item number 53, this matter may be fixed for hearing, Lordship. Date may be fixed, Lordship. That is my.
They will give a date.
Lordship, item number 43, kindly they fix a date, Lordship.
Ah,
Item number
43. What is that matter?
Lordship, petitioner seeking compensation for death of the husband due to electrocution. He's died for the
Yeah,
electrocution.
matter.
Lordship,
It was fixed today, my lord.
No,
pleadings are
you
completely.
mentioned this matter, I remember, na?
Yeah, by Friday, Lordship.
Friday.
Yes.
Friday, no. You mentioned the matter on Thursday?
Yes,
Wednesday.
yes, Lordship.
Wednesday.
That was
On which date he says that the electrical accidents report is against you.
Lordship.
Yes,
Lordship, dispute is that
That was the
I'm
last
employed I'm the employed by the agent of the.
you say that
Yes.
you were an employee. Then
No.
I said why you would not come within the ambit of Workmen Compensation Act.
No, Lordship, it is separate because there is a office memorandum where the honorable this court
Okay.
has allowed to.
His matter to Deepa. List this matter on 29th July 2026 at 2 p.m. for final disposal.
Yes, Lordship.
Obliged.
Anything more? Oh, yes, Mr. Mishra.
Item number 56, my lord. Item number 56, my lord. There is some urgency, my lord. My entire office premises has been sealed by the GST officers, my lord.
Oh,
Yeah, they don't have the power to seal the entire premises. They do not have the power to seal the entire premises, my lord. Under section 67, my lord.
They have sealed it.
Sealed it, my lord.
Good. We do one thing. When do you want it to be desealed?
As per lordship's convenience, any date, my lord.
Chalo. Let's take it out on 30th of July,
My lord.
2 p.m.
My lord.
This is the matter on 30th of July, 2 p.m. Final disposal taking into account the submission made by Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner, that without any authority, the GST officials have sealed the petitioner's business premises.
Office premises, my lord. Office premises. I am the consultant, my lord. Tax
Office
consultant.
premises is not business premises.
Sorry, extremely sorry, my lord.
Business premises, and the petitioner have not been able to carry out his trade and business. The respondents, have they filed their affidavit?
Have not.
The respondents are directed to bring on record their stand by filing their affidavits on or before 28th of July 2026. Who is the respondent? CGST?
State GST.
Oh, tell Mr.